After of the petitioner died on the early morning today, the present petitioner was the only son. One younger brother was there, but he is a mental disorder. Died on today morning.
List for this, but it has been okay.
I supplied the fact.
Who's another?
Bonpal.
Huh?
On good Bonpal.
Take instruction immediately. They're listing at 12 o'clock. Aji. List for 12. Get the instruction immediately.
Step number 74 of 2015. Then that the return I am for the respondent 1. I am the retired bank employee. There was a direction by your lordship to pay the provisional pension during the pendency of the decision proceeding. But in spite of your lordship's order, they have stopped
Give it.
But these two requisitions I have filed in the order on tribunal matter. But I want to these matters may refer to mediation.
Mediation. At a near, sorry.
I am filing for 5 days. It's like another matter. In this case, by virtue of my lord's interim order, the opposite partner 4 is the widow, which is not getting pension, family pension.
Please give it. Give it.
challenging the order of tribunal.
Challenging the order of tribunal.
Terminal benefit of senior citizen.
I mention my lord item 41.
Yeah.
Here I have filed the counter. Counter has not come my lord. Online file.
Who is for the petition?
Petition of Mr. Mishra, I have already talked. He stated that if the matter is gone to mediation center, then
Item 41.
41. I have already
Just
What is the nature of dispute?
dispute my lord bank loan matters. I am for the bank
Loan.
Only 1,69,000.
Mr. Shobhagya Kumar Das, Learning Council, appearing for the opposite party bank, submits that he has already filed the counter affidavit and served a copy in the Learning Council for the petition. The counter affidavit be placed on record. He further submits that the matter can be settled in the mediation format for him. It is to be referred to the mediation.
Right.
Yes.
Supplemental list, item number 1.
May I please? That the petitioner was dismissed from service. And the Honorable President of India has dismissed the petitioner from service, exercising power under
This,
Rule 19.
this original application, counter affidavit, all these things have been filed.
Yes. And 1913.
You are
Where do-
challenging the order dated, order under Annexure 12. Annexure
16 is the
12 and 16.
16 is the Learned Tribunal.
Ajah Tribunal, sorry.
No.
What was your prayer before the Learning Tribunal?
To quash that order.
What order?
Order of disciplinary authority dismissing me from the service.
Why you are dismissed?
Dismissal, it was alleged that the allegation that my activities or conduct that is affecting the sovereignty and security of the country.
Yes.
This is the allegation.
What were you?
I am the assistant director ARC, Charbatia.
Yes.
But on the appointed date, that on the particular date, when I was in my native place at Calcutta, I came across such a from the website that there is a message center, and I booked the message center and I went there, paying 3,500 rupees. When I reached there, police apprehended me because prior to that some allegations perhaps was there with regarding the prostitution and other activities. police also arrested me along with other persons. There, if your lordship will see the annexure 1 of the FIR I have given, and so also pursuant to my lord's direction, I have given all the copies of the police report. There it has been alleged that we were caught along with the ladies, and these are the allegations are there now. And on the basis of that, I was put under suspension under Rule 10(2), your lordship may kindly, because I was apprehended.
What happened to that case?
That case is still pending, my lord, before the trial court, and that has not been finalized. But here, my lord, the exercising power under
But
Article
the investigation, the police found a prima facie case for which charge sheet has been submitted.
yes, my lord.
And now you are facing the trial.
Yes, my lord. That is in the
How many witnesses have been examined?
criminal case idea
So you,
therefore I have submitted.
no, you should, when you are arguing a matter and you know that for this purpose you have been placed under suspension and removed from the service and a trial is going on, you must obtain instruction about the status of the trial. Suppose,
Entire record I have submitted, my lord.
no, not question of record. We just want to know. Suppose in the meantime you might have been acquitted, you might have been convicted, or who knows? So we just want to know that what is the
That witnesses are examination of witnesses are going on.
If you have taken proper instruction, please tell us. Otherwise, we can keep it to next week. You obtain the instruction. Because you are holding such a post, if you indulge in this type of activities, then there would be the question of security of the nation. So you are holding a post in the intelligence and you will this type of offenses.
His activities may, my lord, my humble submission.
No.
Activities may.
No question of may. No question of may. Once you are holding,
See
once you are
the constitutional provision.
My lord?
See the constitutional provision.
Yes, ma'am.
Constitutional provision, just see. When it comes to the national security and all,
Yes, ma'am.
that procedure is waived up.
My lord. 311.
And it is the fact finding that your activities may cause to the threat of the.
My humble submission. Before the learned tribunal, they have submitted the counter only. And your lordship is aware, my lord, honorable Appeals Court has said, where the arbitrariness or illegality has been alleged, it is a duty of the authority concerned to satisfy the court, producing the materials. Objective satisfaction of the court is necessary. And here, my lord, except
What is that? That's the problem. 311(2) is wrong.
here only except two paragraphs in their counter, they have indicated that he has involved such and such, and it is violating that that is called, my lord, the Intelligence Organization Restriction Rights Act 1985. No other allegation is there, my lord.
You see, it is not a question of mere FIR. The FIR has been duly investigated and it has been found that there is prima facie case. We are telling you that is why you have been charge sheeted and you are having several stages after that. Like you could have prayed for cognizance. We do not know whether you filed any petition to pass the order of cognizance. So if that has not been done, you are at a stage of at the charge of stage, you could have filed the discharge petition. That stage, of course, we do not know what has happened. But now the fact remains that you are facing trial, and that is the ground. And this type of, it is not that private dispute or something like that. It's a type of crime which has got some connection that if you mix with such type of persons, likely that there is a threat to this intelligence aspect. So that is the main reason why you are placed under order of suspension. So if it would have been purely private in nature, something land dispute with somebody or something,
I cannot say that. But my humble submission only before your lordships, my lords.
But what my brother is saying, let us understand what is the stage of the trial. If you are acquitted or something, then the story will be different.
Have you got an instruction about that?
My lord, charge sheet is submitted.
That charge sheet has been submitted. This is a offense of the year. As we know that it is a 2016. So charge sheet must have been submitted long. Now,
Yes, sir.
what are the steps? Suppose He might have also challenged the order of taking cognizance. He might have also
No,
filed.
he has not challenged. My
ଜାଣିନି,
instruction is.
instruction ନିଅନ୍ତୁ discharge petition file କରିଥିବ reject ହେଇଥିବ ଏଇ court ରେ challenge ହେଇଥିବ all these things ତାପରେ ବର୍ତ୍ତମାନ trial face କରୁଛନ୍ତି
I will take
ଏଇ ଜିନିଷ ଗୁଡାକ we cannot just ignore these things.
I will take
right. So, and it's
stage of the trial, I will take it.
because of the post and because of the involvement of his involvement in this type of offences.
This is under section 311 2C, my lord.
Right.
That is, my lord, your lordship.
Because of the sensitivity, nature.
Sensitive
Right, that is the exact.
There was a secret investigation. There was a secret investigation.
You get that
which cannot be
whether
disclosed, my lord.
you might have been acquitted, who knows?
Even if he is acquitted, my lord, that will not affect.
Whatever.
I will take it.
No, you have to. The learned counsel for the petitioner submits that as per the order dated 23/7/2025, he has filed the copies of the original application, counter-affidavit, and all the pleadings which was there before the Learned Central Administrative Tribunal, Cuttack Bench, Cuttack, in way number 260/207 of 2018. Stop. There is no dispute that the petitioner in this writ petition is challenging the order dated 15/2018 of the Government of India under Annexure 12, in which he has been dismissed from his service. So also, the order dated 17/1/2020 passed by the Learned Central Administrative Tribunal, Cuttack Bench, Cuttack, in the aforesaid way under Annexure 16. The impugned order reflects his involvement in Baguia T, PS case number 1491 of 2016, which was instituted against the petitioner for commission of offences under section 370, 370B2, 120B34 of the Indian Penal Code, Review section 3, 4, 5B, 5C, 7 and 9 of Immoral Traffic Prevention Act 1956. And in connection with the said case, the petitioner was taken into judicial custody on 16/12/2016 and he remained in custody till 23/12/2016. And it is stated that in the said case, charge sheet has already been filed, and so far as the status of trial is concerned, the land counsel for the petitioner seeks some time to obtain instruction in that respect. Put up this matter next week.
Yes.
What date? Monday or Wednesday?
Wednesday.
Wednesday. List this matter on 13th of August 2025. Mr. Mishra and Senior Panel Counsel shall also obtain instruction in
Yes.
that respect. Yes.
Item 2.
Item 2 and 3, your lordships. Lordships, I'm there on VC, your lordships. I only seek a little accommodation till Monday. I just got recently discharged. Need a little time to
Oh.
till Monday, your lordships. Only till Monday.
All in all, this is Mami also and senior advocate. 6 for an adjournment till Monday. Ms. Mahanti and senior advocate appearing for the opposite party has no objection to the same. Put up this matter on 11th of August 2025. Similar prayer in the other matter, that is sponsored. Okay. So for the matter will come on 11/8/2025. Just a minute. It will be on 13th. My esteemed brother will not be there on that day, so 13th.
In any case, till Monday you need, including Monday.
13/8/2025.
Including Monday.
By the way, how is your health?
Better, Your Lordships. And Aji, better.
Oh.
13.
Item 4.
May I please? Here, madam, my limited grievance is that now I filed a OTS application before the opposite party number 1. That may be considered. I am ready to pay the outstanding. The OTS application is.
We agree to consider it and will intimate.
Then let it go to the mediation.
Mediation, we are sending it to mediation.
Yes, ma'am.
The land and council, both the parties submit that mediation to the format.
Settle there.
Oblige.
Item 5.
Item 5. Lordship, for the bank, last occasion, your Lordship directed me to give the number of section 14 petition. Today the petition is filed. I will get the number by
Let it be on, then Wednesday, you can get the number.
today, 2 p.m. By 2 p.m. I will get the number.
In the court of CGM.
CGM kata. Because previously we
By chance is no anybody also.
Number, can you give the number by evening?
today already filed, my lord. घंटा भीतर number टा मिल जाए.
नहीं, only that, as per Lordship, the effect unless email.
No, the order which you are passing will pass. Only thing is that we have
Yes,
to
yes.
Write the
mention the
number.
number. That is why we do not know that if there would be any defect, they will not register it. That's why we are telling you that.
No.
Are you sure that you can get the number?
Yes, ma'am. There is no defect as per my knowledge in concern.
Yes.
But after filing it,
No,
previously it has been withdrawn.
That what is the? Right.
Defect
Then
number.
why not let us keep it on Friday? What is there?
You give the number so that.
Yes.
The Mr. Anjan Kumar Biswal and counsel appearing for the opposite party bank submits that the bank has already filed the petition under section 14 of the SI Act today before the Land Chief Judicial Magistrate Qatar, and the matter may be taken up on 8th of August 2025, day after tomorrow, so that you will furnish the number of the case, put up this matter.
But what is this number? Annexure 2, you have 118 of 2004.
It is previously withdrawn because the
Okay, withdrawn.
particulars are
Okay,
not
that-
correct.
okay.
Particulars are not correct.
Okay.
For that reason, again it is.
8th of August 2025, yes. Okay.
Item 6.
The Land and Council for the petition is also present, right? So, yes. And the, Mr. You have filed your appearance memo? Mr. Biswal,
No, my lord.
why are you not filing it?
Because the authorized officer is not there, he was on training, today he joined.
No, it's all right. Try to file it by Monday because
Today I have told
your name is not being reflected because you are not filed.
Yes,
it.
yes,
That
yes,
is the
yes,
reason.
yes.
Of course, in the order we have mentioning your
Yes.
name, but listen,
He has come,
Mr. Biswal submits that he will file the appearance memo
Tomorrow also we are sitting.
by tomorrow.
Tomorrow also we are sitting. If we can keep, tomorrow also we are sitting. Telling me question, no, Guru. Yeah.
Item 6.
Please, Lordship.
On the last occasion, your lordships, that submitted the judgment of your lordships in WPC number 21713 of 2024, which was pronounced on 2/7/2025. And they say that it's covered, the present petition is covered. I'm submitting a short note for your lordship's perusal that how both these matters are different.
It's not covered accordingly.
They're not covered.
Give that.
They're not covered.
We are taking it off on Friday. Let him study your note. The learning counsel for the opposite party files a note today in court, handing over a copy of the same to the land central government council, indicating therein that how in the factual scenario the present case is different from the case which was disposed of by this court on 2/7/2025 in WPC number 21713 of 2024. The land council, central government council, took some time to go through the same this matter on
Small
8th
change.
of August.
I am the CGC. I am giving a copy of the note to the opposite party.
You are union of India.
You are union of it.
Union.
Acha. You know, just write it, huh? Okay.
My lord, I am a pardon. Your lordsmith, kindly give a glance my lord's last order. I made a mention before my lord that similar matter between WPC number 13139/2024 is pending, of which order extended to the opposite party in this case, my lord. And I make a prayer that both matters may come together.
That other matter is to be listed.
My lord.
WPC 13139 of.
My lord. Your lordship's order is
All right.
That's the relied upon judgment.
My lord.
The put of this matter with say you 8th review with WPC number 13139 of 2022.
Obliged.
All right.
Item 7.
This matter, my development friend has just filed a convenience note. I just given some opportunity to go through it.
I am just.
Just
He has given a convenience note for your lordship.
go through it day after tomorrow. Tell.
Yeah,
The-
tomorrow,
You have some difficulty.
can it be on Monday?
Monday. Okay. Monday, my brother is not there.
Oh, I'm
It
sorry.
will come on
13th.
Wednesday, 13th. Okay. The learning council for the State Bank of India files a convenience note, which is taken on record. The land council for the copy of the same has also been served on the land council for the petitioner, senior advocate Mr. CORAM, who seeks some time to go through the same on consensus of both the parties. List this matter on 13th August 2025. 13th.
Mr. Kora, you give the name of your briefing counsel.
My lord's,
Your name is right. Give in writing.
Also, along with not Alex.
small humble prayer.
Yeah.
That my learned friend was unofficially need not proceed because on the last occasion.
No, we have already told him.
13-4 are the only. No, we have not gone for anything. So.
So let
that
him
is-
not proceed at least the 13th if the lordship take a.
Yes, that
All
is
of that.
13-4 we have taken. So proceeding under 14 it will take time.
No, 14, it's not 14. The next will be, they have taken symbolic position.
Next is physical position.
Physical possession and advertisement for sale. Let them not go to that stage. So that will make my writ petition infraction.
Milord, up to that date, I say that nothing will happen.
Mr. D.K. Mahapatra and counsel appearing for the State Bank of India submits that till the next date, no further coercive steps are
Miller.
taken.
Writ your petition.
Item 8.
My lord, I'm extremely sorry for not coming with the affidavit as was directed on the, for not coming up with the affidavit as per the order dated 1/8. Because I.
1/8/25.
Mine. That provision was directed. with
Just a minute, let us go to the how much amount the petitioner is ready to deposit as upfront amount. Mr. Pratik Das, Land Council submits that he has instruction to appear on behalf of the opposite party bank and he will file his wakalatnama. Okay. Have you filed your wakalatnama?
It's reflected in the court.
All right. As per the order dated 1/8/2025, the Mr. Das, Pratik Das, Land Council, has already filed the wakalatnama. Wakalatnama ଅଛି ତ record ଅଛି ନା କହିବା registry କୁ place କରିବ on record. ଏଥିରେ ନାହିଁ ସ୍କାନିଂ ହେଇନି। କାଳେ ଫାଇଲ କରିଥିବ ଆସିଥିବ ସେଇଥିପାଇଁ ପଚରା ହଉଛି। କେବେ ଫାଇଲ କରିଛନ୍ତି wakalatnama?
On Monday itself.
Monday? Acha, on 4th of August 2025, let the registry place the same on record and stop. You are supposed to file that affidavit regarding the deposit of the upfront amount. What is your problem?
And I use my personal inconvenience. I could not.
You want for the time?
For the time.
The Land Council for the.
Matter may be placed for there is chance of settlement. Because as per the instruction.
No, unless you say something.
We are
ପଠେଇଦେଲେ mediation କଣ ଦେଲା ଭଟା
ଆମେ ଆଜ୍ଞା 40 lakhs ରେ 41 ରେ ଥିଲୁ ସେମାନେ 50%.
Tell something by way of an affidavit here. That is how we are keeping this matter. We do not know what would be the outstanding dues against you. We just want that what is the upfront amount you are ready to deposit, file an affidavit. That much you are also not able to do, and we will send the matter to the mediation.
Next week any day my lords may fix the date.
Give that affidavit. But something positive should come from your side also.
You have to show your bona fide otherwise.
13th of August 2025. Yes.
Item 9.
Next week, ma'am.
Mr. Bishwa, you have filed your wakalatnama?
No, madam. They have sent the wakalatnama. It will come from Sanpur, madam. For the reason, by Monday I will file it.
Next, we have statement.
He is supposed to tell us.
Same thing, that upfront amount.
Nice, we are giving indulgence because it will be settled. Not that you file it and take advantage of this proceeding and don't pay there and linger on.
No, I will pay.
Oh, then you pay.
I will obtain instruction next week.
You see, now this mediation drive, which is known as mediation for the nation, that is going on. That is how in every court you must be finding that this type of cases are listed, which can be referred for mediation. That if you delay the matter, we will not see anything. Why we take this? Otherwise, you will pass one line order that it is alternative remedies available. Go there and so since look, the Mr. Biswal and Council submits that you will file his wakalatnama by Monday, that is 11th of August 2025. Stop. And Council for the petitioner seeks some further time to obtain instruction and file an affidavit by the petitioner regarding his that how much amount he can deposit as upfront amount, so that matter can be referred to the special mediation level, that is mediation inverted comma for the nation. All right, put up this matter on 13th of August 2025. And in case the Mr. Biswal files the wakalatnama, same shall be placed on record and his name will be reflected in the proceedings. Yeah.
Item 10.
Right, number 10. But the only outstanding is 16 lakhs for some odd miller. They have already taken symbolic possession of my property. Day before yesterday, they have made the paper publication. But I am ready to deposit the entire amount, miller. To show my bona fide, today I will deposit miller 5 lakhs. Let the
ମୌଖିକ କହିଲେ କିଛି ହବନି, ସେ ଆମେ ସେ ପଠେଇ ଦଉଥିବୁ. Why not, if you say that you are ready to deposit today 5 lakh,
yes,
outstanding due is 16 lakh, we can definitely send it to the mediation. But
yes,
why don't you ask your client to file an affidavit to that?
he is in the
Your
bank.
client is ready.
Yes, miller.
So ask him, he is here.
Yes, miller.
Ask him to file that one-page affidavit is
Yes,
sufficient.
miller.
All right, Mr. Kaur,
Give me a copy. And
we are mentioning it, but we are mentioning that you have filed the affidavit. If you file, it will be tagged and you give it to the court master.
yes,
All right.
yes, miller.
Let
No, my only friend is-
May I suggest something?
let it come even tomorrow, then he can come up with the affidavit. And
All right, the land counsel for the
And
petitioner.
pay 5 lakh, then only come.
Yes,
Land counsel for the petitioner submits that the petitioner is ready and willing to deposit the sum of rupees 5 lakh before the bank in course of the day. And he also is also ready and willing to clear up the entire dues of the bank within a stipulated time as would be fixed, and it is a fit case for referring the matter to for mediation. Mr. Coral and counsel appearing for the State Bank of India has received
the copy of the writ petition.
has been served with a copy of the writ petition. Stop. Let an affidavit of the petitioner be filed regarding his willingness to deposit the amount, so also to pay the balance amount, upfront amount of rupees 5 lakhs, and to clear up the balance amount within the prescribed period. Put up this matter tomorrow. You file it in court.
Tomorrow or day after tomorrow. All these things he will do and hand over me copy also. I will take instruction.
You have to take also instruction. So better you give it a copy so that you mention this 5 lakhs you mention, 5 lakh you deposit today.
yes, ma'am.
बाकी जो अमाउंट टाकू आपण केत दिन भीतर देबे सेटाको एफिडेविट रे इंडिकेट करंतु, give a copy so that he will also take instruction from the bank and apprise us day after tomorrow. List this matter on 8th of August 2025.
I have given a OTS application before the bank. Along with that application, I have.
Once it goes to the mediation, it will be done.
Yes, ma'am.
So that is why we just want to show your bona fide, to deposit the amount, file an affidavit, give a copy to Mr. Kora. It will be listed day after tomorrow. Okay.
My learned senior only undertakes that no courses action will be taken in the meantime. That
Bhartaman kichhi
Eight ଭିତରେ କଣ ନେଇଯିବ? Eight ପୁରା day after tomorrow. 8th is day after tomorrow.
already
No, no.
published.
Public cell
We
which date
are
it
only
has been
trying to find out a way out to get it settled.
Yes, ma'am.
Once stage granted, then you will seek
Only
adjournment.
my learned senior submission may be.
By day after tomorrow, nothing will happen.
day
At
after
least
tomorrow.
this notice has not been published in the newspaper. Only
Already
13/4 is there.
No, already published.
Published?
Yes, my lord.
What is the date of?
Cell date.
The day before yesterday.
So where is that? No, if you have been paper publication, you should have annexed it. Why have you not annexed it?
After filing of the writ application.
Why we
When
have
the
an
date is
amendment?
fixed now.
Yes, my lord.
କଣ ସେଇଦିନ ପବ୍ଲିଶ କରି ତା ପରଦିନ ତ
No, no,
ରଖିନଥିବେ?
No, my lord.
ଆପଣ why are you not filing it with the copy? ଦେଖନ୍ତୁ, Land Council for the petitioner submit that there has already been paper publication regarding e-auction, and you will file also the copy of the newspaper clipping by tomorrow. Next.
Item 11,
E-auction sale.
No, here I have challenged the order of the tribunal issuing debt certificate as well as warrant against me. I am neither a loanee nor a guarantor. My name has been tampered and a recovery proceeding, but the recovery bank and CBI was handed over the charges. Your lordship may look at annexure 1. The FIR. It starts from page 10, my lord. Page 14, your lordship may.
You see, it is on the basis of the order passed by the Debt Recovery Tribunal,
My lord.
which is dated, what is the date?
The warrant I have challenged.
3/4/2018,
My lord.
3/4/2008.
Decree has been passed.
No, then what happened?
My lord, how the court, what have been done, your lordship may look.
No,
at.
no.
Then in pursuance to that certificate,
Yeah.
tribunal passed an order for issuance of a death certificate. Death certificate is issued and now it was executed.
No, no.
Now warrant has been
This-
issued against me.
This, the order was passed on 8/4/2000. If you come to the annexure 5,
My lord,
which is the warrant of arrest,
my lord.
we find that the recovery certificate is dated 8/4/2008.
Behind my back, I was.
The file. That amount is rupees 15,57,280.
My lord.
And along with the interest 12%.
My lord.
Okay. Then that was sent to the recovery official.
My lord.
And
In-
then what has happened that
Right. Ultimately, tribunal adjudicated
you
the
are
matter.
commanded to return this warrant. Acha. In that connection, after this order was passed, 8/4/2008,
My lord.
thereafter what has happened? Why it has gone to the stage of issuing the warrant of arrest again?
What happened in this case? The bank manager with the connivance of the loanee, a loan was granted. He was my brother. He tampered my signature
No.
and take a loan.
8/4/2008 ପରେ ଆପଣ
ମତେ କିଛି notice sir ହେଲାନି. I have sworn the affidavit. No notice was sent to me personally.
then how all on a sudden
This warrant has been reached.
say are you not a party in that proceeding?
Yes,
Way
ma'am.
number 1 of
I
2000.
was a party.
Then
I was a debtor.
if after receiving and you were also present and you were hard and this
No.
Then-
I was not hard.
no, after receiving summons, if you do not, you are a in that case you are the petitioner or what?
I was the guarantor.
Uh,
Bank was the
who
applicant.
filed that application?
Bank.
Bank filed that.
Bank filed that application to
So,
issuance of the
no.
certificate.
So notice must have been issued to
My
you
lord,
and you have appeared.
no, I have not applied.
Why you did not appear?
The notice has not issued to me.
You
I
said
have never received a notice.
You said show us that order dated 8/4/2008. That notice
Alright.
was not.
Your lordship may look at.
Because the alternative remedy lies with you. If you are a party, in spite of receipt of the notice, you did not appear and the order has been passed, you could have challenged it before the DRAT.
How can bank made me a party when I am not a loanee nor?
We do not know what is the order passed.
Therefore, I said that your lordship may look at annexure 1.
No.
A audit was made. Bank manager with the connivance of the loanee.
This entire warrant has been issued because of that order dated 8/4.
Yes, ma'am.
Is it not correct?
Yes.
So are you not supposed to file that order dated 8/4/2008?
My lord. 8/4/2008.
ଆରେ ଲେଖା ହେଇଛି ପରା ଆପଣଙ୍କର ସେଇ ଯୋଉ ୱାରେଣ୍ଟ ଟା ଦେଇଛନ୍ତି ତା ଉପରେ ଲେଖା ହେଇଛି ଯେ ରିକଭରି ଅଫିସର କୁ କେମିତି ଏଇ ଯୋଉ ଓଏ ନମ୍ବର ରେ ଏଇଟା ଡ୍ର ହେଲା ଏତିକି ଆମାଉଣ୍ଟ ସେଇଥିପାଇଁ ତାପରେ ପ୍ରୋସିଡ କଲା ତ
ଆଜ୍ଞା।
ବେସ୍ ହଉଛି ସେଇ ଅର୍ଡରଟା 8/4/2008 ର ଅର୍ଡର ଆପଣ କହୁଛନ୍ତି ସେଟା ବ୍ୟାଙ୍କ ଫାଇଲ କଲା ନୋଟିସ ମତେ ଇସ୍ୟୁ ହେଲା କିନ୍ତୁ ମୁଁ ନୋଟିସ ପାଇଲିନି ତ ସେ ଅର୍ଡର ଦେଖା ହେଇଥିବ ନା
ଅର୍ଡରଟା ଆନେକ୍ସ କରିଛି ନା ବ୍ୟାଙ୍କ ଟ୍ରିବ୍ୟୁନାଲ ଅର୍ଡରଟା ମୁଁ ଆନେକ୍ସ କରିଛି।
କାଇଁ
My lord, that is annexure. That is annexure. A copy of 26/4/2007. Page 25 to 29.
in this case you are opposite party number defendant number
4.
defendant number
Page 26, lordship may look at.
Saroj Kumar Pradhan
Saroj Kumar Pradhan.
and এটি লেখা হয়েছে counsel for the defendant number 4 হচ্ছে none.
None. This order was passed. Then your lordship may look at the next annexure.
Please come to paragraph number 3.
My lord. Paragraph number
3.
Defendant number 4 remain ex parte.
That means you have received the notice, you did not appear.
But I have never received a notice.
And order sheet, you bring out that order sheet because this is reflected in that order. There must be some order that in spite of service of notice, you did not take steps. That is how you are set ex parte. And that is how it has been ultimately reflected in the main order, which is
My point before. That what your lordship says, I shall come. Now the warrant has been issued against me. I collected the papers. The minimum papers I have required. But your lordship may look up to one aspect of the matter. When neither I am a loanee nor a guarantor. How can the bank proceeding against me very well known? A CBI case is pending.
ଆପଣଙ୍କୁ ଯେତେବେଳେ notice ହେଲା, are you not supposed to appear and tell the same thing before the tribunal?
That notice I have not received.
That is why you are telling that you are not filing the order sheet, and the order reflects that you are set ex parte. Ex parte does not mean that without any notice, service of notice, or without any refusal, the court would have written in this way that
You are a guarantor.
Yes, no, I am not a guarantor. That I am saying. I am not a guarantor.
But in
look at
para 2, it says that defendant number 2 to 4 stood as a guarantor.
Lordship may look at page of the FIR 20 page 24. Your Lordship may look at that FIR. CBI case has been instituted.
Mr. Mishra, you please produce the order sheet number 1.
Your Lordship may look at it.
Disputing number 2, you are to satisfy us that why you did not challenge this order which was passed by the DRT before the DRAT.
I have said it is passed behind my back. Page 24, your Lordship may have a glance, my lord. Page 24 of the brief.
Time without number, it has been told to us that many decisions that
My lord, I know.
alternative remedy is
But
available.
then I am not a loanee, neither a loanee nor a guarantor.
But the order
That
says,
knows that I am not a loanee.
1 minute.
Bank proceeded with you against me.
order says on 13/7/2001.
Time glance to page 24.
You
I
entered
will not
into
take
tripartite
much more
agreement.
time of my lord. Page 24. Investigation further revealed that signature of Sri Saurabh Kumar Pradhan, petitioner, is available in the guarantee form for the aforesaid loan. Sri Saurabh Kumar Pradhan is the brother of the accused. Sri Saurabh Kumar Pradhan denied having signed on the said letter of guarantee and disowned his signature, which is also corroborated by GEQD. Accused MK Pradhan with dishonest intention has produced a fake guarantee form purport to be signed by Sri SK Pradhan to obtain the said loan. The loan amount has become NPA with an outstanding balance of such and such. Then your lordship may look at the final form.
Have you not entered into a tripartite agreement?
No.
To say no, then these are all disputed things. You are not going to the DRAT, you are disputing what has been stated here. All those things have been mentioned.
No. One aspect.
On the basis of that tripartite agreement, the thing was sanctioned.
If I
Now you are telling that I am
not a borrower, nor
Where your signature is forged, where in that tripartite agreement or somewhere else? In which document you
Loan
are
document.
for?
and a CBI case has been instituted, an inquiry has been made. CBI was approached by the bank itself. How can bank proceed against me?
You should have told all these things by
But no notice to me.
Order passed by the loan recovery officer is also appealable before the presiding officer in view of section 30 of the RDB.
June.
Milord, I'm coming with most of the day.
Mr. Sahoo Land Council.
So by according to the appeal,
That
and
he
it
has
is so many
instruction.
times the notices have been sent
All
to
right,
the party for the brief.
file an affidavit to that effect. Submit that he has instruction to appear for the opposite party number 1, opposite party number 1, Central Bank of India.
Well,
And are you filing the,
course of the day I will file.
and in course of the day, you will file the wakalatnama. Stop. He further submits that the matter may be taken up day after tomorrow, so that
Milord, 12th, Milord, day.
12th it will not come, it will come on 13th. Submit that the matter may be taken up the next week, so that and a copy of the writ petition be served on him, so that he will obtain necessary instruction in the matter. Let the Land Council for the petitioner, Mr. Mishra, serve a copy of the writ petition on Mr. Tuna Sahu during course of the day, and the matter be listed on 13th August 2025.
and you file also the written statement filed by.
Milord, everything I will bear. So many times I will.
All right,
Grievances would I will put for the recovery officer.
File all these things.
So it a payment they have put you.
And most of the thing that order sheet you dispute which and the जे एक्सपर्टी ये कौन पे एक्सपर्टी हला तार रीजन ता थी यस नेक्स्ट
warrant may not be executed.
No, Milord, this is a, for a,
Yes, sir.
on Supreme Court has categorically stated for
We are
avoiding
not-
the statutory fees.
No,
they are filing.
When I am not a loan bank, no, it and I will file a case against me.
My lord is aware of this.
yes yes next item number 12
Item 12.
People kindly turn to page 4 of my petition.
Huh?
Present outstanding more than 6 crores. And this is the observation of the apex court.
But I have not
এই
yet
কেসে
started,
অ্যাপেক্স কোর্ট পর্যন্ত যাইছিলে না অন্য কেসে
On the case.
Oh.
I have not yet started my case, but
But come to your prayer.
right, Lord, I am not on.
How can this
suppressing.
prayer be
I am
allowed?
not on suppressing, Lord. Lord, I am on a simple and small prayer that look, I have represented you. I want to settle the amount. I want to pay the entire thing. You have communicated to me thrice or twice saying that you please increase your proposed amount. I have been increasing it. You are not rejecting my application, and that stage it is pending. Now you are putting my property on
Amount
auction
of-
on 8.
no Mr. Please what is the amount have you given a copy to him
No.
right ପଇସା ଦେବେ ସିଏ ଆଉ ତାଙ୍କୁ କପି ଦେବେନି କେତେ ଟଙ୍କା ସିଏ ଜାଣିବେନି ତାଙ୍କ ଏଗେନଷ୍ଟ କେତେ ରହୁଛି ଆପଣଙ୍କର
In physical possession, they have also signed in the physical possession.
ଠିକ ଅଛି ଟୋଟାଲ ଆମାଉଣ୍ଟ କେତେ ବର୍ତ୍ତମାନ ଆଉଟଷ୍ଟାଣ୍ଡିଂ
6 crores more than 6.
6 crores give a copy have you got an extra copy of this out
Yes, thus I have got it from the.
That's why I see
ତାଙ୍କୁ
that
copy
same
copy
notice.
କରିଦେଲେ ସେ ଯୋଉ ଇଏ ସିଲଟା ମାରିଲେ କୋର୍ଟର ସିଲ ମାରିଲେ ତାହେଲେ କପି କରିଦେଇଦିଅନ୍ତୁ ତାଙ୍କୁ ଗୋଟେ ଦିଅନ୍ତୁ ଦିଟା କପି କରିଦେଲେ
Kindly see their sale notice, which is true. Lord, I don't want to dispute the whatever amount they are saying, that is on record, Lord. But sale notice 2 crore 59 lakhs, and their notice to me also 2 crore 59 lakhs.
Mr. Ratha, this amount is now, he has
They are
mentioned
suggesting
6
that they-
crore and all.
Right.
So, please go through it and make an affidavit that how much you can pay
Right.
and how do you propose to fund it so that it can be at least referred for mediation.
That will happen.
Plus, receive the copy first. But don't give such paltry amount that it will.
Yes, certainly, Lord. I'll instruct my client to come with a good amount.
Right.
That's what I have already said to him. Looking at the stringent position of law,
Okay.
I have said to him.
What was the last communication
Lord,
by bank saying what was the amount?
That is page 63 month. Kindly see, they are demanding upfront 50, whereas their scheme says it should be 25.
2.7 crore, huh?
Kindly see, man. Yes.
Yes. That is July 2025.
Yes.
How it becomes 6 crore now?
Yes, my lord.
Your last letter is 31/7/2025.
Yes, my lord.
July
There are
20.
various accounts, my lord. There are several
I'm
accounts.
talking about one
It may be the one account, there are other
No,
loans
no,
there.
this is 4 accounts.
ଏଇ ଯୋଉଟା ଏଇ ଫିଗରଟା ଯୋଉ ଦେଇଛନ୍ତି
Again.
ଏଟା କଣ ତାର ଚାରିଟା ଆକାଉଣ୍ଟ କୁ ଟୋଟାଲ
ଚାରିଟା account.
କରିଦେଇଛନ୍ତି ଆଚ୍ଛା
ଆଚ୍ଛା।
ତ ଇଏ କଣ ଏଇ କେସଟା ଫାଇଲ ହେଇଛି ଚାରିଟା ଆକାଉଣ୍ଟ କୁ ନେଇକିନି
ନା, ନା, ନା।
ଗୋଟେ ଆକାଉଣ୍ଟ କୁ ନେଇ ଫାଇଲ
ନା ସାର୍ ସବୁ ଆକାଉଣ୍ଟ ମୁଁ ଆଡ୍ କରିଛି ପେଜ 4 ରେ ଦେଖିବେ ଇଭେନ୍ ଯୋଉଗୁଡାକ ଆକାଉଣ୍ଟ ନୋଟିସରେ ଇନକ୍ଲୁଡ ନାହିଁ ତାକୁ ବି ମୁଁ ଆଡ୍ କରିବି I want to settle all the accounts and get rid of the bank. That's all.
Yeah. या देर अकाउंट नंबर टा कोडी मेंशन करू
My lord, page 50, page 1,
annex
page
3 annex 3
63, page 63.
page 63
Where is the account number?
Sir, said actually ଦେଇନାହାନ୍ତି।
ସେଟା ତ ପ୍ରଥମେ ଲେଖିବା କଥା with reference to account number ସେଇଟା କେମିତି ଛାଡି
କିଛି
ଦଉଛନ୍ତି
ଦେଖୁନାହାନ୍ତି।
ଜଣଙ୍କର ଯଦି ଚାରିଟା ଆକାଉଣ୍ଟ ହେଲା ଆପଣ ଦେଖୁଛନ୍ତି ଓଟିଏ ସଫର ହଉଛି 2.70 crore is it for all the account
No,
or
no,
it's in
There are
respect of
various
a
accounts.
particular account
Which account you are talking about? 63, page 63.
ଯଦି ଏଇଟା ହଉଛି ସବୁ ଆକାଉଣ୍ଟ ପାଇଁ ତାହେଲେ ଆପଣ ମେନସନ କରିଥାନ୍ତେ ରେଫରେନ୍ସ ଯା ଲୋନ ଆକାଉଣ୍ଟ ନମ୍ବର ସୋ ଡେଟ୍ ଗଲା ତାପରେ ଆମେ ସେଟଲ କରିବାକୁ ଚାହୁଁଛୁ ଓଟିଏ ସଫର ହଉଛି ଏଇଆ ଆପଣ ଟୋଟାଲ ଆକାଉଣ୍ଟ ନମ୍ବର ହିଁ ମେନସନ କରିବେନି ତାପରେ ମନେ କରନ୍ତୁ ସିଏ ରାଜି ହେଇଯିବେ ତାପରେ କହିବେ ନା ଏଇଟା ହଉଛି ଗୋଟେ ଆକାଉଣ୍ଟ ଏଇଟା ଅନ୍ୟର ନୁହେଁ ତ ଇଟ୍ସ ନଟ୍ ବି ଲାଇକ୍ ଦ୍ୟାଟ୍
If this is correct, then July it was 2.7 crore, now it's 6 crore.
31/7/2025 ରେ ଆପଣ ତାଙ୍କୁ ଅଫର ଦଉଛନ୍ତି 2.70
People are there to buy this.
ବର୍ତ୍ତମାନ 4 ଦିନ 5 ଦିନ ଭିତରେ କେମିତି ହେଇଗଲା 6 କୋଟି ଟଙ୍କା ଆପଣଙ୍କର
People are there behind this problem. I'll show it to my client. Let him take also.
ଦେଖନ୍ତୁ the learning council you are Mr. Mishra na
Yes, madam.
Mr. Sivodotto Ram Prasad Mishra, Land Council appearing for the Bank of India. File some documents relating to the outstanding dues against the petitioner. गोटे अकाउंट लिखाई अकाउंट नंबर होची 100
गोटे अकाउंट केमती
नहीं तो एटा तो अलग अलग अछि सब এইটারে মিস্টার রথ এই जो पर्टिकुलर केस रो ये लोन अकाउंट नंबर केते
My lord, I am giving that number.
ए आपण सेकंड पेज को जानतु
Third page.
सेकंड पेज रे से जो लोन अकाउंट से 4 दिन होची 6 कोटी केते टका पड़े
It होची account number 5021.
लास्ट टू 01 हां
अच्छा एटा. This is not part of the notice. Your lordship will find it page 4 of my restriction. Mahavir Food Processing.
अपन लास्ट तीनटा नंबर कहले अपन को लोन अकाउंट नंबर टा जोटा की केस सहित संपृक्त अछि
021.
021 तो ठीक अछि सेकंड पेज ना सेकंड पेज ऑफ दी आज जोटा देइछन सेकंड 2021 रो होची 6 crores funds
Right.
राइट
Okay.
आपण ए जो ओटीएस ऑफर करथिले अनेक्चर 10 रिपीटिशन कॉपी अछि अपन का
Yes, madam.
सेतरी जो अनेक्चर 10 रे देइछले 2 कोटी 2.70 is it in respect of this particular loan account?
So all loan account.
कारण आपको यदि हमें मिसेई दबु ये तो गुडाय टका हे जो 628 है
ये पारा फोन
सर ये वाला तो सब एंट्री कौन पता था
ये पारा फोन
ऐसी चार्टा लोन अकाउंट रो देइछन फिगर ताजुरु मिस्टर ऑफ
How many account you have in fact? 1, 2,
I have
3, 4, 5,
yes, 1, 2, 3, 4, 5, 6, 7, 8 accounts.
8 accounts.
How it has become 8? Original CC account, CC became defaulter. So as to regularize that account, they have created 2 term loan accounts. So that becomes 3. So 1 CC used to 2 become 3. So another CC equally 2, they become 6. The 1 CC account, they became a defaulter. To regularize that, they have created 2 more loan accounts, term loan. And that term loan finance amount paid to CC loan account.
But you, Mr. Rotha, we are recording your submission that this particular relates to this 021.
No. This relates to all 6
All the
accounts.
6 with the para 4.
Mahavir Industrial, Mahavir.
All 6 accounts. If your lordship see page
And
49.
just a minute.
Right.
And this OTS offer which you have given
It is in respect of
2.7.
Mahavir Industry. There are Mahavir Foods also.
हमें पचार to plain and simple. Annexure 10 or 2.70 crores, whether it is in respect of all the loan accounts or any particular loan.
Particular loan. Mahavir Industries, madam.
My lord,
महावीर इंडस्ट्री हमें जानिनु हमें दरकार से लोन अकाउंट
my lord, page 49 kind.
And
My
he is the
OTS proposal
proprietor.
page 49 देखो.
He is the proprietor of Mahavir Industries.
Sir, page 49 ये देखिए.
The Pradeep Kumar Rao.
One second, Mr. Minister. Kindly see page 49. My OTS on which they are issuing this letter. I have given proposal for 6 accounts, naming the loan account names. Kindly see.
annexure
Page 49, annexure 4. Final closing of all 6 accounts. And they are saying that it is 2.70 for all these 6 accounts. This is the original application which has emanated and has culminated in that order.
Hmm. 50% ଆପଣ ମତେ ମାଗିଛନ୍ତି ଯେ you are advised to deposit at least 50% of the OTS of amount,
Upfront.
upfront amount.
Upfront
for
50% is
consideration
not
of
the
the.
RBI guideline. That says at 25%.
All right, you take down the so documents. A copy of the same has been sought on Mr. Rockland, senior advocate, who seeks some time to obtain instruction in the matter. Mr. Rothop pointed out that on 5/7/2025, the petitioner has submitted a proposal for closing the loan accounts and he was having 6 loan accounts.
Right.
So he further submits that on the basis of such application, the letter has been issued by the bank on dated 31/7/2025, wherein no account number has been mentioned. However, it is mentioned that so far as the OTS offer amount of rupees 2.7 crore for full and final settlement of the bank dues is concerned, the petitioner was instructed to improve the OTS offer amount and was also asked to deposit 50% of the OTS offer amount as upfront amount for consideration of the OTS offer. When we put a pertinent question as to whether this OTS offer of rupees 2.70 crores, which is mentioned in the letter under annexure 10, is for all the loan accounts, the land council for the bank submits that he wants to obtain instruction in that respect. Upon Niyasun, don't make such a submission. Karan eta house through Jana Purchi, that's what Fabutaka bank dues fines offer not only for a particular loan out.
The letter itself, they have not mentioned the Mahavir puts, they have not mentioned. Only they have mentioned the Mahavir interest.
But ye tar is in for settlement of all the bank dues. CB modhya tankar application ne deithile mor sabu gudako loan account settle kariya pai. So obviously the bank has considered that it is perhaps the settlement of loan or settlement of all the bank, not a particular loan account, right? So, and the Mr. Rothland, senior advocate, submit that he will file an affidavit by the petitioner that in pursuance of such letter under annexure 10 dated 31/7/2025, how much the petitioner is ready and willing to deposit at the moment as an upfront amount. Copy of the affidavit is served on the land council for the bank in advance put of this matter. Kebe rakhiwa phone to? 13th of August 2025. Yes.
Sir, I'm very optional profession.
No one.
Is optional. People are already there. 5 offers have already come.
They have already, the physical possession, they have also signed. We have inserted the security guard. They have signed.
If they
As
sell
per
away
the-
the property,
yes,
what?
yes. The borrower has signed in the physical
That's
possession.
right. Physical possession has been taken
That's
out,
right.
but don't sell it. And let them not sell it.
The land council for the bank has also filed some documents that physical possession of the property has already been taken off. So and so file an affidavit so that the matter can be referred to the mediation. Okay. as per the mediation for the nation jota drive রয়েছে সেই ওয়ার্ডিংস টা রাখি yes
This does not say it in the kindly protect to that extent.
that process is on or কোটা বর্তমান কোন স্টেজ রয়েছে
ম্যাডাম অলরেডি 1 তারিখই আছে ম্যাডাম
Option পাই আছে
অপশন পাই আছে তো আজ অপশন তো 8 তারিখ আছে
8 September.
so you pass sir instruction give the oral instruction that let them proceed with the auction 8 but don't finalize it till at least 13th so that you may consider his offer also what he was given okay on that
Great.
Item 13.
The writ appeal has been dismissed for default on 31/10/2022. The petition has filed the CMAPL for restoration of the writ appeal matter. There is delay of 22 days in filing the restoration petition.
have you given a copy to the state council
Yes, I have also filed.
for whom you are appearing Mr. Naik
Mela.
state का आप ही
Copy
appear
हम
कर
करना है.
ଗୋଟେ କପି ଦିଅନ୍ତୁ let them check at least for whom you can appeal do not fire making presiding officer of state educational tribunal as a party
Mela.
you will file objection to the your delay condonation application कहाँ पे अपन appear करेंगे
5
हाँ
Director Secondary Education.
director secondary education
Deputy
Odisha
Director in the Sanskrit and Special Education.
5-6
Mela.
ଆଉ ଏଇ ଯୋଉ ଅଛି ସୁପରିଟେଣ୍ଡେଣ୍ଟ ସାଂସ୍କ୍ରିଟ ଷ୍ଟଡିଜ ଏଗୁଡାକ ସେମାନେ ଯିବେ appear କରିବେ ଖୋର୍ଦ୍ଧା ସାଂସ୍କ୍ରିଟ ବିଦ୍ୟାଳୟ ଏଟା ସେମାନେ ନୋଟିସ ଯିବ
Notice.
ସୋ 1 କୁ ନୋଟିସ ଯିବ 3 କୁ ଯିବ 4 କୁ ଯିବ ଆଉ 7 କୁ ଯିବ ଠିକ ତ
Mela.
alright ଲେଖନ୍ତୁ IA number 295 of 2022 there is an application for condonation of delay in filing the CMAPL. The stamp reporter has pointed out that there is delay of 22 days in filing the CMAPL, which arises out of writ appeal number 445 of 2018. Top. The Land Council for the state accepts notice for opposite parties number 5 and 6. Let the copy of the CMAPL petition along with the 2 interim applications be sought on the Land Council for the state. So issue notice on the question of limitation. No, ऊपर लिखी देवे तापर एटा state accepts notice कर देवे तापर so far as requisites for issuance of notice opposite party number 1, 3, 4 and 7 shall be filed by next week. You file the requisites speed post warrants. No notice to issue to opposite party number 2. Put up this matter after 4 weeks. Objection, if any, to the delay condonation application be filed in the meantime for consideration for the interim application is the condonation of the. Yes.
IU 394 of 25 dispensing with filing of certificate copy.
Certified copy of the dismissal order.
I have filed the uploaded copy. That may kindly dispense to.
We'll pass the order on that day. Yes.
Progress.
Item 14.
Item 14, let me give some time. This record is not with me, only petition and counter. Annexures are not there. I should give some time. I'll assemble the records.
Mr. Pari, it is available with us. You can take the soft copy in the pen
Yes,
drive.
yes, today I'll take a pen drive. Yes, my lord, it is helpful. Yes.
Who is appearing for the other side? That means for the petitioner, Mr. Rotho. 2007 matter. No order has been passed and he is not appearing. But order is challenged. Set aside the order dated 15/12/2006 of the Central Administrative Tribunal, Annexure 3. of Premature. Pending interested non-obvious for the petitioner. Mr. Paril and Deputy Solicitor General is present. It's a writ petition of the year 2007. And the case has already stopped 5 adjournments. The writ petition stands dismissed for non-prosecution. Yes, next.
That is the
Next.
Item 15.
15, item 15. That matters that against the order of priority, where that issue was status quo order, despite the status quo order. I had actually completed the arguments were completed. The lordship directed to file a written note. My learned friends, I have filed my written note, but so far as this part is concerned, this status quo part, I have prepared a list of dates pertaining to this status quo. That your lordship. Okay. It's the piece that you are vote for. Just when I appeared, when the status quo order was passed, when I have given for your lordship's comment. The written note of argument of yours you have already filed.
Already filed.
Mr. Mishra, you have filed. You are just filing today.
I have given a date chart with a little bit of submission at the end of it.
Let us see your first now.
I just wanted to bring your lordship one thing, which was not originally brought to your lordship notice. First thing, 2 brothers. One is the loanee, one is the guarantor. When the NPA was made, they agreed to pay some amount, 32 rupees. Then again became NPA, again paid some amount. Therefore, 2-3 dates of NPA are there. That was disputed, but that has been explained. Second thing is, when the amount is demanded, one brother through another person filed a suit for specific purpose of contract. Another brother through another person through a suit for specific purpose of contract. One suit was dismissed or irrelevant. The other one rejected, and that was challenged in a higher court. In the meantime, interim order was passed, that was vacated. Again, it was challenged in appeal. Interim order was passed. That your lordship has already seen. The lawyer was to be given a copy of the interim order. Usually appears, Mr. Balkrishna was usually appears for the bank. It was never communicated to the bank. In the meantime, sale has taken place. Sale certificate was granted. Thereafter, the council informs. That document is also there, which you have seen. So there was no prior information. But banks normally, if they get information of the bank, they stall everything. They can't go beyond the court's order. Everything was complete. Then actually, if your lordship looks at the matter of challenge in appeal, before the DRT court that did not challenge the sale. They did not challenge anything. Rule 8 has been violated, or Rule 9 has been violated, or say notice was not served. Nothing was challenged. Only point is that stay order was there and it has been sold. It was, and the court remanded without examining all those things, saying that no, sale is bad. That was challenged in appeal. Appellate court has dealt with, but in 3-4 paragraphs. I think you must have seen that. I have indicated para 12, 13, 14 to 18, 19. Appellate court dealt with each one of the points and said that the DRT authorities did not examine these points, which itself says that the person never challenged anything, and he cannot say that it is to be set aside. And eventually came to a conclusion that it is also barred by time. 17 has not been upheld against 13.2, 13.4, 14 or sale. Nothing has been challenged. So, and here the communication was not there. Therefore, it cannot be said the sale is bad. Law says, Supreme Court says, once sale certificate has been issued and you have not challenged the sale, it is confirmed. You only get back the money. But there is one mistake committed by the bank. Annexure 16, after the sale certificate was issued, and mark my lord.
OTS.
Yes. After the sale certificate was issued, that means it has been concluded. That's a mistake committed at the bank. They realized and refunded the amount of 1,40,000, saying that there's OTS amount that was the deposited. He deposited 25 lakhs after the DRT court passed the order. That was also High Court directed you refund the amount. That has also been refunded. On the other accounts, there is some due. Therefore, that 4 lakhs was withheld. That has also been explained. So therefore, so far as this case is concerned, there is no list to invoke and challenge the sale itself. Sale is confirmed. I filed those decisions also that
Not only sale certificate was issued, but you issued this type of notice and you received the money also from this. That's it.
for the purchaser.
No. From me.
No, we have not received anything prior to sale certificate.
No. 1 lakh upfront we give that amount, that is.
No, 1 lakh.
OTS.
OTS you receive.
Sale certificate.
Yes. That's what I'm saying.
After completion of the sale, that's a mistake committed by the recovery officer, which was reconciled and it has been restored.
So sale certificate date you have also given.
I
have given in my after the sale certificate, it is not correct that sale certificate?
No.
After the sale certificate, you give the OTS offer.
Yes.
No. And not only that, you also receive the money. Whether it is not correct. OTS offer dela pare ଆପଣ ମଧ୍ୟ ସିଏ ଡିପୋଜିଟ୍ କରିଛନ୍ତି ଆମାଉଣ୍ଟ ଯୋଉଟା ସେମାନେ ରିସିଭ୍ କରିଛନ୍ତି upfront amount.
Upfront amount they usually file along with the application they file.
No, for the 30-10-2000.
But that is required to be given to consider his OTS. But at that time, the sale was complete. So that
How the tribunal deals with this aspect?
So tribunal says sale has been completed, sale has not been challenged.
The OTS after the sale.
OTS, but neither it was raised. So first time there. No, sir.
Let us see the tribunal whether that point is tribunal has dealt with or not.
Yes.
Let us. I'll show that.
Two Mr. Mishra, two things we want to see from the tribunal's order, also from the appellate order, about the stay order passed by this court, and in spite of that, the sale was.
I'll show that.
Number two, that after the sale certificate was issued, you issued this OPS and he deposited the amount, and how the both the courts, that means tribunal as well as the DRAT, has dealt with it.
Can you look at Annexure 1?
Yes.
You are placing the DRAT order.
Appellate order. At page 35, paragraph 12. Having heard the counsel for the parties and
paragraph 12.
Paragraph 12.
This is on what point? In paragraph.
They have dealt with in different. I'll just show that so that it deals everything.
Okay.
Having heard the counsel of the parties and considering the material on record, it is apparent that essay was filed on 30/12/17 after taking physical possession on 2012-2017, seeking relief to quash the sale certificate at 12/6/2017 for maintaining status quo on the property in question, because they say status quo was there, it has been sold. As such, no relief regarding the demand notice or possession notice was sought. It was not challenged. Even no relief was sought with regard to setting aside the order of the district magistrate passed under Section 14 of the SARFAESI Act. There is no dispute the proposition laid down by the Honorable Supreme Court in Kanhaiya Lalchan that the order passed under 14 is a step taken under Section 13(4) of the SARFAESI Act, give rise to cause of action to the affected party and challengeable for DRT. But the order of district magistrate doesn't entitle the owner of the property to challenge the earlier steps after passing such order, because every step taken by the bank gives rise a separate cause of action which requires to be challenged at a relevant stage within 45 days from the date of the measure. It is not a case that the respondent bank demanded notice or possession notice or sale notice were not served on him, or they were not properly affixed or published in accordance with the provision of law. Thus, the respondent was required to file the objection on Section 13(3) capital A of the Act if he was having any grievance with regard to the contents of the demand notice. No such objection was raised despite service of the demand notice. Further, the symbolic possession was taken on 4/7/2016, but the same was not challenged within 45 days. The respondent had waived his right to challenge the same. As such, obviously, the relief granted to the tribunal below, qua demand notice, possession notice, sale notice were time barred, because it was to be challenged within 45 days. No application for condonation of delay was filed, nor any delay was condoned by the tribunal below. Rather, this issue was not pondered over despite the objection taken by the bank in its counter objection. Thus, all the reliefs granted in this regard were time barred. In para 4 of essay pertaining to limitation, it was stated that cause of action arose on 2012-2017 after taking physical possession of the premises, but that cannot be a ground to challenge earlier steps. For that purpose, only the possession and order of district magistrate could have been challenged, but no ground was taken, nor any relief was sought. Thus, the tribunal below has passed the order without considering this aspect of limitation as liable to be quashed on this ground alone. Since the merit of the matter have also been argued, so turning to the merit of the case, guarantor has not pleaded categorically that the demand notice, possession notice, or sale notice were not served. Since no objection was raised after issuance of demand notice, so the issue with regard to date of declaration of account as NPA cannot be raised in the application filed before taking possession. Even otherwise, the appellant has stated that respondent has deposited some amount after the first demand notice on 6/2/2015. Therefore, after classifying the account NPA on 28/12/2015, fresh demand notice was issued on 24/2/2016, thus mentioning of different date of NPA doesn't suffer from any infirmity. So far as the valuation of the property is concerned, the bank has obtained valuation report from the approved valuer, which was not contradicted by the respondent at relevant time. If the property was being sold at a lower price, the respondent, Ashok Kumar Das, guarantor, was free to produce another buyer. Apart from this, the owner of property sold the self-same property as the agreement to sell. Already sold means agreement to sell to Samarendra Nanda for a meager amount of 3 lakh. So it cannot be said the property was sold at a lesser price. The valuation report submitted by the respondent was obtained after 1.5 years from the date of sale. So it cannot be taken to be a true report applicable to the time of sale conducted with the bank. The case law then cited, I am not referring to, para 17. With regard to status quo order dated 12/5/2017, passed by the Honorable High Court, in which the bank was also added as a party, there is nothing on record to show this order was conveyed to the bank before auction of the property and issuance of sale certificate on 12/6/2017. On the contrary, the letter date 17/6/2017 is on record, demonstrating that the bank was informed about the pendency of civil appeal before the Honorable High Court, which was written by the advocate to the AGM bank. So, bank was not aware of the order of the Honorable Court before 17/6/2017. The sale certificate was issued on 12/6/2017. Thus, the principle laid down in Sujit Singh that the stay order, any order is passed. It is worthwhile to mention after the confirmation of sale deed was executed, possession of the property is also handed over on 20th 12 2017. That the sale becomes absolute. The borrower guarantor have never appeared before the bank to redeem the property before publication of sale notice. This is important, Malad. Therefore, the right to redeem the property has been extinguished. The valuable right has been created in favor of the auction purchaser. Thus, the tribunal below has erred in allowing redemption of the property. Further, tribunal below has directed to calculate interest at 10% simple from the date of demand notice. It is apparent against the provision of Act because while deciding essay, the tribunal has to analyze the steps taken of the bank and cannot quantify the amount, much less the less capability of rate of interest. Issue of applicability of rate of interest. This way, also the order impunity is sustainable. Observed above, although the issue of taking possession of the property on 20th 12 2017's compliance with the district magistrate order was within limit, but firstly, the respondent has not pleaded in any of the grounds to challenge the order of the district magistrate. No relief was sought for quashing of the said order or restoring back the possession of the secured assets. Now, the relief was not needed, cannot be granted. Secondly, this issue was not argued before the tribunal below. No finding has been recorded in this impugned order on this aspect, so this cannot be entertained at the appellate stage. If the respondent was having any grievance with regard to the non-recording of finding, he was free to challenge the order to this extent, but no such appeal was filed. Thirdly, the only objection is with regard to the NPA, as mentioned in the affidavit for the district magistrate on 30/11/2013, but the bank has mentioned the date of NPA as 28/12/2015 in subsequent demand notice. So this way, there is a variance of the date. The district magistrate is not required to make any inquiry about the contents mentioned in the affidavit. He has satisfied as to whether all the points required under 14(1) of the Surface Act was covered in affidavit or not, and district cannot go into the niceties of the contention. So it cannot be said that there is any irregularity in the order of the district magistrate or the possession of the property has been already been delivered to the auction purchaser on 2012/2017. Therefore, the same cannot be restored back on the ground of redemption. But 13(8) has been amended. But after the amendment, once the sale becomes notice has been issued,
That's settled.
no redemption is permissible.
But in the counter, where have you explained regarding the OTS proposal and the exception?
So the OTS proposal may be a wrong.
What have you said in the counter?
In the counter?
Yes.
No, wrong. It has been issued by mistake.
Where have you?
Yes, kindly say in the counter. We have admitted that it has been issued.
Admitted,
We can't
but-
say no, madam. Obviously. But sales certificate is issued. But there is a gap between the communication maybe.
Where? What have you said in the
Yes,
counter?
I am indicating.
Counter, let us see.
The counter is sometimes. I've stated something. But, therefore, I have candidly admitted in fact. Sir, page 1110.
With reference to particular paragraph.
Para 10, Marat.
Your counter is
Paragraph 10 A, B, C, D, जो grounds would have
Oh, sir, to page 10, sir.
Paragraph 10.
No, sir, page 10, page 10.
Page 10 means
Second para, sir, para.
it is
Sub para
submitted.
what?
It is
It
submitted.
is submitted here that.
Okay. Date where their loan
It is the
account-
fact that the opposite bank has issued the letter stating therein that the loan account borrower was eligible. But the offer given to the borrower was not acceptable for a draft was returned with information that the offer so it's not acceptable to the banks.
Not said anything.
The specific point explain that or given that it by mistake or what happened.
Where have they said?
No, that is not good. That is not.
Sir,
They said that it was not acceptable
fact
because-
remains that such a letter was issued. Let me be very candid in my approach. And it could not have been issued. But even if it is issued, doesn't create any right. The reason being,
It was
prior to
confirmed. The sale was confirmed. That's the submission.
prior
But
to that,
on record, you have to say, take a stand insofar as that issuance of OTS is concerned, because that is a specific case.
sir, it is not the specific case. Sir, kindly see, that was not the ground on which they have challenged. That was not the ground. Say, it's an incidental. So, para 10 of say the case para 10 Rabi. The secondly, OTS amount offered by the person and so is not acceptable to the bank under the scheme which the bank has already intimated the borrower and current. But that's the wrong thing.
Where in the writ, where have you said that OTS? Where have you said that?
In the
part?
read it is mentioned.
Sir.
May I read it?
Yes. Which part?
Sir, page 16 of the read. To date chart where I
Date chart.
29
Was it a ground?
2017.
These are the facts which is unfolded.
Yes.
But where is the ground? Ground of challenge
I
to
don't-
the
that was a-
DART order.
Why not? Just one
So
second.
the ground actually,
Ground
that
is
was
not-
not the ground on which they have challenged.
No, that
These are the
the
facts.
tribunal takes note of it. I will show it to
No,
you.
no, here in the read itself.
Tribunal has not taken note of it.
Tribunal has taken note of it. Tribunal has taken note of it. Your Lordship may see. The first tribunal. The first tribunal.
Here, yeah.
So read पे किसी ground नहीं.
Later you have not taken.
If Lordship looks at the REIT application, that is not the ground. But the Supreme Court has condemned the bank. But if you are in that decision, Supreme Court has condemned the bank for their conduct.
Page 25, ground E.
I'll show that judgment for it.
Ground E I have taken. And the tribunal has taken this into account at page 61. Page 61, paragraph 8 of the tribunal. Sorry. The DRT one. DRT, page 8. The tribunal further observed that after receipt of the letter of the applicant deposited 10% down payment on death date, but the authorized officer returned the demand draft and offer not acceptable under extent scheme. It is noticed by the tribunal that 9/11 property was sold and sale certificate was issued. Amount was adjusted as per show cause filed by the respondent bank. Amount is already adjusted and statement of account which is filed by the respondent clearly shows that applicant is paying the amounts regularly and there are several credit entries to the account on Ethte and amount of rupees 1 lakh paid by the applicant issued notice on 30 to borrower and the account.
That's in a different context.
Different context.
Not regarding that OTS.
Yes, yes, upfront, 1 lakh those.
No, that is regarding the NPA. While dealing with the
No,
NPA,
this tribunal,
there's a-
it is of the letter applicant deposited 10% 30/10/2017.
Please come to that paragraph number 10 of your counter affidavit.
Yes, madam. Correct.
Paragraph 10.
10.
Which starts that in reply to facts stated in paragraph A, B, C, D, E.
Sir,
You come to the.
it is submitted that the sale.
Just a minute. Every counter affidavit first.
Page 123. Just
123.
1, 2, 3.
That is 1, 2, 3, paragraph number 10.
Yes.
You come to in the middle, you have stated.
Secondly,
Secondly,
yes,
the
OTS
OTS
amount offered by the petitioner under
Rina Samadhan scheme.
Some Samadhan scheme is not
Is not
acceptable to the bank.
acceptable to the bank
Scheme.
under the scheme
The
for
bank has
which
already
the bank has
intimated
already intimated.
There
this
must be
one.
some scheme and
Oh, that is
betweenly
what
they
was-
might have said it.
So there was a scheme. Perhaps if you would have deposited according to that scheme, you would have accepted that. That was the reason, not that you said that it is on that ground you rejected that because sales certificate.
No, not on that ground.
Your offer is under a particular scheme, but what he offered, that was not acceptable under that particular scheme.
Yes, absolutely correct, Millard. So let me clarify the position.
That means, no, you are telling something else. You are telling that it was just a mistake
It's not an
committed.
inadvertent because it was issued to everyone, maybe. In that process,
It
might
was
have
not
gone.
a commit, you are telling that a mistake has been committed by issuing such a letter, but it is not a mistake. There is a scheme, under that scheme, perhaps you issued it to the petitioner that, but whatever amount he offered, that was not acceptable to the bank under that particular scheme. That is why you,
That may not be a mistake.
Why I say mistake, let me clarify. Why I say it's a mistake, any scheme, then maybe this scheme also.
Once sale is confirmed, the scheme is not applicable. That's what you want.
That is exactly.
Still routinely they might have issued.
Scheme was there, everything is correct.
Yeah.
But sale was, prior to that, sale certificate has already been issued. Therefore, the bank
everything
has,
is concluded.
it's a mistake on the part of the bank.
It's all.
all right, anything further or we'll close it?
That is what exactly.
Second date chart
And sir, sir, Dixon, the paragraph that you highlight for the.
The land council for the Mishra.
Have you filed the decision? Have you filed this one?
Yes, sir, should I give another two
No,
copies?
earlier you filed, then it must be there.
Fine.
You filed earlier?
It's fine.
Because in this Mishra, you have just mentioned only one decision, we think.
One decision.
2024.
That is written confirmation of sale.
Bafra Motors case.
Confirmation of sale.
All right.
13.8 should analyze correctly, comparatively.
Land council appearing for the opposite party number. Opposite party number.
1 to 3.
Huh? Bank means three, only three, na? Authorized officer, State Bank of India, because the others are, one is Safe Recovery Appellate Tribunal, registered so and so, and District Magistrate Collector, BGO.
Yes, sir, only female.
The opposite party number 3. Why we say so? Because in this date chart, Mr. Mishra, you have mentioned that opposite party number 1.
I may have one piece of.
No, 3. Correct. This corrected. So that is what we little confusion arose.
Okay.
District magistrate pay for the state.
Give it.
The state.
Give it to me. Correct.
No, give it for correction. That is not for opposite party.
They say they will. Sir,
Say it again.
3. Number 3, na?
If you
Opposite party number 5 pay and friend.
No, it's all right. Land Council, Mr. Mishra, Land Council, Associate National Advocate, appearing for opposite party number 3, State Bank of India, has filed consider heading the account resurrection. Please give it to us.
Submission.
the decision ଅଛି
Date chart with your.
ସେ decision ଦିଟା ବେଶୀ ଅଛି ନା ଦି ଦିଅ
Taken on record.
check up କରିଦିଅନ୍ତୁ
The Land Council for the petition has filed a list of relevant dates, which is taken on record. Hearing is closed, judgment is resolved.
sir ଏଇ ଯୋଉ ସେଲିର NLP sir ଅଛି ରେକର୍ଡ ନା ଆଉ ଦିଟା ଦେଇଦେବି
That is, they are not
Give
necessary.
it must be.
ଆପଣ କେବଳ ସେଇ ଗୋଟିଏ ଏଡିସନ ଦଉଛନ୍ତି ଯଦି
ଗୋଟେ ଏଡିସନ
ତାହେଲେ ଆଉ ସେଟା କଣ ଅଛି ନୋଟ ସେଟା
ଆରେ ପୁରା ଡିଲ୍ କରୁଛନ୍ତି
small. So we are just coming within 2 minutes. Okay, you, Morijala was part of it. IN number 2170. Obviously, it is not pure, now chief.
Verified.
ये आइए किसी अपन ग्राउंड नहीं ना दी जो डेथ ऑफ योर फादर बिकॉज इट वाज फाइल्ड अर्लियर ये जो आईए नंबर 2171 which is for interim bail which has come for consideration. Have you taken any ground of your death of your father?
First para one is the elder son and
Oh,
only.
अच्छा अच्छा father of the expired on 6 April. ठीक है. You are the eldest son.
Yes, and he was also granted interim bail free tax and surrender in the.
No, that's all right.
Expired today.
Right. Lovely. IE number 2171 of 2025 is an application for interim bail on the ground that the father of the petitioner expired today and the petitioner is the elder son who is to perform the obsequious ceremony of his father. In the first hour when this matter was mentioned, we asked the learned counsel, actually this matter was not in the list and the one being mentioned, it was directed to be listed by way of special notice, it has been listed. We asked the learned counsel for the state to obtain instruction and accordingly the learned counsel for the state has obtained the written instruction dated 6/8/2025 from Inspector in charge of Bond Park Police Station just on board, where it is mentioned that the father of the petitioner has expired today and as he was sick and bedridden for a long time and the petitioner being the elder son has to perform the obsequious ceremonies. The written instruction is taken on record. Learned counsel for the petitioner submits that earlier the petitioner has been released on interim bail 3 times and after lapse of interim bail order he has surrendered at right time. Stop. Considering the submission made by the learned counsel for the respective parties, the amendments taken in the interim application, the written instruction received by the learned counsel for the state, we are inclined to release the petitioner on interim bail for a period of 20 days from the date of release. The order be uploaded and urgent certified copy and matter be listed after such and such date. He will file the surrender certificate. And while on interim bail, the petitioner shall not involve in any criminal activity. Yes.
Item 16.
Item 16, my lord. I have already filed counter to rejoinder to file by opposite partner of 6 as well as the reply to I number.
Just a minute. On 16/7/2025, this matter was taken off. On that day, we have mentioned that Opposite party number 6, counsel for the appeal 6, served a copy of the counter affidavit on the learned counsel for the petitioner to 2 weeks time to file the rejoinder affidavit. So you have filed your rejoinder affidavit.
Yes, Lord, I have filed e-file, but not tagged to record, my lord. I am solving a
That has come on record today, but scanning for the scanning, and you are serving a copy. So please go through this and take up next week. The land counsel for the petitioner has filed the rejoinder affidavit to the counter affidavit filed by the opposite party number 6. The copy of the rejoinder affidavit has been served on the learned counsel for the opposite party number 6.
No, all the opposite.
For all the opposite parties.
Kindly put up on week commencing 18th. Next week rather.
Put up this matter in the week commencing from 18th of August 2020. Interim order dated 7/7/2021. साथ-साथ 21 तो shall continue till the next week. On consensus लिखी जाए है ना 18/8/2025 interim order की consensus.
Item 17.
Ready for you.
Sorry?
We are appearing for the Union of India. You are appearing. So we asked you the other day that you can get free service from the High Court Legal Aid Panel and you can assist the counsel.
I have got many other cases. I'm ready for a hearing.
How many cases you have filed before this court?
This court single bench also. This matter was dealt in a single bench.
No, you said that many cases I have argued the matter. That is why we are asking you. How many cases you have filed and
this matter was already.
Don't leave this matter. You said just made a statement that you have argued number of cases before this court.
The 3 cases already I have written.
It all relates to you.
Yes.
What are those 3 cases?
This related to this matter.
Yeah.
Already this matter was dealt by single bench. And this matter came to, I am a railway employee.
No,
And also a disabled.
this matter was before the single bench.
Yes, dealt by single bench, and to single bench I came because of the previous order was passed by State Commissioner for Persons with Disabilities. And that order was against me, for which I challenged that order for the Honorable Single Bench.
What happened?
The Honorable Single Bench again cancelled the order of Disability Commission and remanded the matter to the State Commissioner for Persons with Disabilities to pass order on merit of the case.
Which order you are challenging here?
I am challenging the order of Central Administrative Tribunal.
Dated
29/10/2021.
That is Annexure 22.
Yes, ma'am. My lord, I came to Central Administrative Tribunal because the State Commissioner for Persons with Disability passed order completely in my favor and directed that the punishment imposed by the relay, that is compulsory retirement from service, is invalid in law. But and directed the General Manager Bhubaneswar to pass fresh order. But the General Manager again passed the order imposing compulsory retirement on me, for which I went to that is the contempt petition. And contempt petition was also dealt by the Honorable Single Bench. And Honorable Single Bench said that the Disability Commission directed the General Manager to pass order, and somehow the order has been passed by the General Manager, and accordingly you challenge that order, General Manager order. Contempt is not forthcoming, and I dropped the contempt proceeding. Then I came to
the cat, Honorable Cat. That Honorable Cat passed order without going to the merit of the case and stated that there is little scope of interfering with the order of disciplinary authorities by the honorable courts and accepted the order of general manager, for which I came to this honorable court. And my lord, this is a case for termination of service, that is for alleged 22.5 days of unauthorized absence from duty. That was 2.5 days CL, that was regretted, and 20 days LAP, EL, that was.
It appears, just a minute, it appears that a departmental proceeding was initiated against you.
Yes, yes, sir.
And in that departmental proceeding, the ultimate order was that
My lord, you hold for second.
you have been removed from the service,
Yes.
right? So why the departmental proceeding was initiated?
My lord, departmental proceeding was initiated because.
What are the charges?
Charges was only 22.5 days of unauthorized.
Where is the charge?
That is 41,
Huh?
writ petition, page number 41.
41.
Yes, sir. Forty-one to 44. Charges is on page number 43. There is no other charge, my lord, only 22.5 days of unauthorized absence from duty.
Now, what is this memorandum to hold an inquiry against one so the substance of imputation of misconduct so on so in respect of is out is enclosed in the statement of the charge. Okay. That means this is the okay, that is in page 43 it is mentioned.
Yes, yes, my lord.
Article 1
Yes.
that Sri Jayachandra Mishra was working as
OS 1, Office Superintendent 1.
Office Superintendent 1 under Senior
DOM Sambalpur.
DOM means
Divisional Operations Manager.
Divisional
Divisional
Operational
Manager.
Manager. SBP. SBP means
Sambalpur.
Sambalpur has committed severe misconduct by absenting himself from second half of 12/10/2009 till 4/11/2009. Such unauthorized absence on the part of office superintendent is highly irregular, shows lack of devotion to the duty, and by this act, Sri Mishra failed to maintain devotion to duty, acted like unbecoming of a railway servant in contravention to Swachan, thereby rendered himself liable for disciplinary action. So, statement of imputation in support of so-and-so, committed so-and-so, absenting himself on till dated so-and-so. Sent an application for 2.5 days. Sealed through the staff of so-and-so and was intimated by Tribunal over telephone that the applicant for so-and-so from indicated still he did not turn up for duty, son of highly regular. So, all right, you submitted your CL that is for only 2.5 days.
My lord, they have only mentioned about my CL application.
What happened thereafter? Why did you for the other days?
My other days I have submitted leave application. That is the available flag 10. Flag 10 of the.
Have you told all these things in your reply?
Yes, yes, everything is there. The judgments are also enclosed.
Where is that CL application is in?
My lord.
Anisha?
My lord, flag 10, I am showing you.
Flag 10.
Okay.
Acha, flag 10. Flag 10 is the list of rules. We just want to see your application.
Just
Have you annexed a copy of it?
Yes, yes, my lord.
You might have filed along
No,
with
black
your,
pen,
along with your reply to the
Page number
Page number 40.
page number
20.
40.
40.
My lord, I just want to take some water. I'm a liver patient and when I talk to
Page number, no,
40, 40.
take it please. When there is no permission, take your drinking water. 40, Mr. This is an affidavit in the writ petition. We want that application. The writ petition, page number 40.
Then it's flag 10. That is flag 10.
Flag 10.
Oh, yes, rejoinder or everything covered. That has not been serial number. Flag 10 has been marked.
Flag 10 कौन ଅଛି? Flag 10 रे ठीक click कले आसुची list of rules.
That there it is attached. Page number 40.
Page number
40.
40 अच्छा.
Please application.
अच्छा. 40. होची 40 ଟା ଗୋଟେ format ଟା ଅଛି.
My lord.
दादेर applicants पर नाम लिखा है जय चंद्र मिश्र.
Yes, my lord.
One so no.
Leave application has been submitted in that format.
Leave application.
Yes, my lord.
এটা period केबे टू केबे जाय election.
My lord, that is
Sanction for 20 days.
Yes,
20
yes.
days LAP.
15/10/2009 to and onwards for
I have to attend my
mother's critical condition of my mother.
When you submitted this application,
This application was received on 16/10.
where is that?
My lord, the next page, that is page number 42. And my chief office superintendent in charge, he admitted that the application is received. That means the LAP 20 days application from 15/10/09 was given on 16/10/09. He has admitted, my lord. Page number 42. And this application was, my lord, not entertained by the authority. And there is erasing, that is page number 40. There is complete erasing and manipulation. It's at the top of the application. That was not entertained at all. And the CL, as per railway rules, it will not deny my CL. Clear, but there is a provision in the railway rules.
Well, which is that provision?
Who has erased all these things? Page 40.
Just the rule. These are the second page, that is CL.
Casually.
Casual leave, my lord, second page number 2.
No.
That is, casual leave is not recognized and is not subject to any rule. Technically, therefore, a railway servant on casual leave for half a day or full day is not treated as absent from duty, and his pay is not intermitted. Casual leave, however, must not be given so as to cause evasion of the rules regarding also. Last note, full pay is admissible to a railway servant on casual leave if in any case less than full pay is allowed, it would amount to an imposition of a penalty not provided for in the discipline and appeal rules. But they regretted my CL application. That is put to 39. Just to previous to my CL application was 39. Yes, my lord. Like that.
Where is that regret?
Regretted left side. That is.
Is there any time limit prescribed that for how many days it can be taken or what is to be done? Yes.
CL, my lord, there is no.
No, we do not know because you have just given a part of it. We do not know that what is there. Actually, suppose you take it for some days and then
The CL,
it takes
10 days CL.
different type of leaves as it appears. One of them is casual leave.
Yes, my lord.
But we just want to know from you because this particular application,
Yes, my lord.
you have stated for the total number of days is 20.
Elect, my lord. CL 2 days, my mother condition was serious, but that is I could not resume after completion.
ଏଇ ଯୋଉ application ଟା ଆପଣ ଦେଇଛନ୍ତି
ଆଜ୍ଞା।
flat 10 ରେ ଦେଖଉଛନ୍ତି
ଆଜ୍ଞା।
ଯୋଉଟାରେ ଆପଣ ମାଗିଛନ୍ତି 20 ଦିନ
ଆଜ୍ଞା।
ଏଇଟା କୋଉ ଟାଇପ ର application ଆପଣଙ୍କର?
এটা ইএল ଯୋଉଟା ଆମର ଷ୍ଟେଟ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଯୋଉଟା ଇଏଲ କୁହାଯାଏ।
ଆଁ?
ଇଏଲ ଆର୍ନ
On leave ର
Yes, ma'am.
on leave ର ରୁଲ କଣ ଅଛି? କାଜୁଆଲ ଲିଭ୍ ଆମେ ବୁଝିଲୁ ସେଇ ଯୋଉ
ଆଜ୍ଞା।
ସେଟା
ଆଜ୍ଞା।
ବାକି ଯୋଉ ତା ପରକୁ ନେଇଛନ୍ତି ଯୋଉ 20 ଦିନଟା ନେଇଛନ୍ତି ତାର ରୁଲ କଣ ଅଛି?
ତା ରୁଲ my lord next page. That today which rule I have submitted, that is rule 503. Rule 503.
Right to leave.
My lord 503 page number 4. Right 503 right to leave. Leave cannot be claimed as a right, and a leave of any kind may be refused or revoked by the authority competent to grant it, but it shall not be open to that authority to alter the kind of leave due and applied for except at the written request of the railway servant.
So here is a case of refusal. So once you submitted this application
Yes, my lord.
for grant of leave for 20 days,
Yes.
It was refused and it must have been communicated to
Not
you.
entertained.
Huh?
This application, the 20 days leave application.
Regarded, it is regretted.
Regretted means
CL is regretted, my lord. CL is regretted, but that 20 days application is not entertained. There is no remarks on the page number 40 leave application. And then after that leave, I resumed duty on 16/11. My lord, there was correspondence, that is I
No,
submitted.
come to page 39. Page 39, after flag D,
39 is
you
regretted.
have sought
That
that
is regretted.
extension for the leave. I have threatened my mother, so
Yes,
this is the 12/10/2009 to
Yes.
14/10/2009. This is regretted.
This is CL application. That is regretted. Then, but as per rule, that should not be regretted. And then I submitted a LAP application. That is page number 40. And that was not entertained. And there was erasing. My lord, for this erasing and manipulation, I have also, a FIR was also lodged in the GRP Sambalpur.
Who has done it?
My lord, that was manipulated. There is,
Who has manipulated?
sir, that authority manipulated. Because they give me charge sheet, 16/11, 5/11 charge sheet was issued, and they communicated me 16/11/09. At that time, before that, no communication was given to me. Whether my leave was sanctioned or rejected, that was no communication was given to me. Then, my lord, when I came, I sought my application. When my attendance register was marked unauthorized absence, I sought my application. And that is the reply of Chief OS, that is page number 42. He stated that in his application, 2.5 days CL application duly rejected by CODM Sambalpur was informed to you on 13/11 over mobile phone. Well, this was not correct, and they have not submitted any call details, etc. The copy of the same is enclosed. The copy of same was sent to your residence. It was not taken.
Please come to one thing. You come to your original application and show us that relevant government statement and what is the reply given by the other side, Union of India. Where is the original application?
Original. They have admitted, my lord.
We want to see it.
They have stated that, my lord.
So we are, you are challenging the order passed by the London Tribunal.
Yes, my lord.
We just want to see the pleadings before the London Tribunal, and that is why the perusal of your pleading your ground taken and what was their relevant reply, so that we can assess the judgment or the order passed by the tribunal in a better manner. That is, have you filed that original application copy?
My lord, all the documents, matter the case file is
ଆମେ ଆପଣଙ୍କୁ simple ଜିନିଷଟା ପଚାରୁଛୁ।
ନା original copy my lord file करने कारण बहुत bulky ଅଛି ଏବଂ all the documents
ମୁଁ ଆମେ ସବୁ ଆପଣଙ୍କର document ସବୁ ଯୋଉ OA number 64P of 2019
ଆଜ୍ଞା
ଏଇଟା ଆପଣ ଫାଇଲ କରିଥିଲେ
ଆଜ୍ଞା
ତାର original application copy କାହିଁ?
copy ଟା my lord remove करनी କିନ୍ତୁ relevant all the materials
We have told to all the parties, including the Union of India, that whenever you are challenging the order passed by the Central Administrative Tribunal, please file the original application. If any written statement is filed, any rejoinder is filed, please file those documents so that we can have a better idea that what was your pleading, what was the written statement, and on that basis, how the tribunal has come to the finding. So unless you file those documents,
instead of entire document, I have filed my written note of submission.
no, the written note of submission will not do.
That is,
You are to file the original application, and you must have they filed any written statement or counter affidavit to your original application.
Yes, my lord.
So that you are to file. On that counter affidavit, have you filed any rejoinder?
Yes, yes, my lord.
So all those pleadings should come before us. You file with a memo, the copy of the original application. We do not want any further document, nor your all the bulky document. We just want this original application, the written statement or the counter affidavit filed by the other side, and your rejoinder affidavit. After rejoinder affidavit, anything else they have filed or that completes the pleading.
That completed.
So tinita jinsa, original application, counter affidavit, and your rejoinder. Right? So ଏଇ ତିନିଟା ଜିନିଷ ଆପଣ ଫାଇଲ କରନ୍ତୁ। ଅଛି ଆପଣଙ୍କ ପାଖରେ ତ?
ହଁ my lord.
କେବେ ଫାଇଲ କରିବେ?
ଆଜି ଫାଇଲ
ଦିଟା ସେଟ୍ ଫାଇଲ କରିଦିଅନ୍ତୁ ହେଲା? We'll take up your matter next week.
my lord, ଏଟା ସିମିଲାର ଯେ କେସ୍ ରେ ଆପଣଙ୍କର କ୍ୟାଟ ଜଜମେଣ୍ଟ ମୋ ଅର୍ଡର ପରେ
ଆପଣ ଇଆଡେ ସିଆଡେ ଯାଆନ୍ତୁନି। ଆମେ ଯୋଉ ଅନୁଯାୟୀ କହୁଛୁ ଆପଣ ମାଇଣ୍ଡ କୋଉ ଅନୁଯାୟୀ ମେକଅପ୍ କରିଛନ୍ତି ଆମେ ଜାଣିନୁ। Ultimately, we are to be satisfied that in what way the order passed by the London Central Administrative Tribunal is erroneous, whether it is likely to be interfered with or not. So that should be on the basis of your pleadings in the original application, the counter affidavit, the rejoinder, the analysis made by the court, these things we are to verify. So that is why you have not filed, please file it. And again, we are telling you, if you seek the assistance of any counsel from the panel, you can be provided freely. Okay, that also you think it over. Right? Look on the petitioner appearing in person has filed the copies of some
rules.
अच्छा एटाକୁ ତାଙ୍କୁ ଦେଇ ଦିଅନ୍ତୁ, he will file the rule ଗୁଡା ଦେଇ submits that he intends to file the original application, the counter affidavit filed by the
entire pleading.
The entire pleading version. Original application, so also the entire pleading, which was before the Central Administrative Tribunal, and put up this matter. Kebe available have a
Next Monday. Last 13 years, my lord, I am struggling with this case.
ଆଜି କେସ୍ ତ ଆମ ପାଖରେ ଶୁଣାଣି ଆଜି ଆରମ୍ଭ ହେଲା, ଆପଣଙ୍କ ଏବେ 13 years pending ଅଛି. Are we responsible for that?
Continuous ଚାଲିଛି. My lord, I am not.
When are you available? Next week, when are you available?
This petition is pending from 2021. How you are telling that 13 years it is pending?
For that department.
For that upon con korthi hoyi jalla.
Next week, madam, my lord, Monday. Today I will
Monday
the documents.
There is some problem with so
You would
Put up this matter on 18th August 2025. Mr. Santosh Kumar Samantray, learning Central Government Council is present. There is no for them.
Maybe taken up night.
19th ରେ ଅଲଗା ବେଞ୍ଚ ରହୁଛି ପୁରା ମଙ୍ଗଳବାର ଆଉ ଯୋଉ ଗୁରୁବାର ଅଲଗା ବେଞ୍ଚ ରହୁଛି ସେଥିପାଇଁ 18 ତାରିଖ।
Any copy that may copy may be sought to me. କାହିଁକି ନା ମୁଁ instruction ଆଣିକି copy ଆଣିଲା ବେଳକୁ ମତେ ବି
original application ଯାହା pleading entire pleading ର copy ସେ ଦିଟା set ଦେବେ
that is a dismissal
copy ଦେବେ କହୁଛନ୍ତି copy needs to be also supplied to the land council for the
ତାଙ୍କୁ କପି ଦେବାକୁ ପଡିବ।
my lord, with much difficulty I have obtained it to pen drive, my lord, as per your lordship's direction.
Okay.
File ନାହିଁ ତେଣୁ ଗୋଟେ copy ଦେଇଦେଲେ
ଦେଇଦେବେ next
Item 18,
Wait, please, please. There was a direction of the lordships to file an affidavit. Lords, I have filed that affidavit. Pursuant to that, they have filed another reply, which is not yet on record. That will be brought on record.
just a minute. Front to front, as per order dated land council has filed an affidavit with some photographs along with circumstances. So it will submit that they may be given some time to go through the to file, okay. You have filed your reply.
Yes, well, on 29/7.
That has not come on record.
Not been brought on
Every file कले कौन
On 29/7/2000.
Okay, it has come and but it has scanning has not been made, so official scanning will be made. Left on
I only seek to file a rejoinder to this.
the land council for the
Opposite party no one lot.
opposite party number 1
Lots.
as file reply to the affidavit filed by land council for the opposite party number 1 filed the reply to the affidavit filed by the petitioner. कहीं से order तो देखा first
2525.
filed by the petitioner in pursuance of the order dated 25/6/2025. The stop copy of the reply affidavit has also been served on the land council for the petitioners. Mr. Acharya, land council submits that appearing for the petitioner submits that he seeks some time to file his response to the reply affidavit. Put up this matter on the chancellor state के उठ के title of the
Any date?
Tell us a date, both of you, whenever you will tell after 1 week, we will fix the date. But it should come from both of you, otherwise we will put it on according to
What's Saturday?
27, huh?
Sorry.
27 is a holiday.
29th. 29th. Or first week.
Let it be on 1st September.
Let's interim order.
1st September 2025. There is an interim order.
Okay.
Interim order dated once for continuous till next.
Okay.
item 19,
I'm to the opposite part number 2, my lord. The last order direction to file an affidavit, my lord. Also, allow me kindly 2 weeks more time to file an affidavit.
Petitioner as well as opposite party number 2, both you took time to file affidavit.
It is today I am filing the affidavit.
Acha, diyo.
Serving the copy, you file the affidavit. I am serving the copy.
Petitioner.
I am also serving copy to the state.
As per the order dated 16/7/2025, the London Council for the petitioner No, as per the order dated 24/3/2025, the Land Council for the petitioner has filed an affidavit. Copy of the affidavit has been handed over to the Mr. Mahapatra, Land Council appearing for the opposite party number 2.
And state also.
So also to the state in court today. The affidavit is taken on record. Mr. Mahapatra's Land Councils for the OP2 submits that he may be given some further time to file the affidavit. Kebe rakhiwa upon the 2 weeks. 2 weeks after. So put up on 1st of September 2025. 2 weeks time. Okay.
State will be directed to provide me a counter state.
State counter affidavit नहीं
फाइल ही
हमको देना थी कॉपी
कॉपीटा देंगे देखिए तो टेक्स्ट आइटल देखो ठीक है
अच्छी तो ऑपोजिट पार्टी नंबर 3 तो अच्छी तो आपको देना दी कॉपी देना चाहिए
कॉपी देना था
Dita copy the Land and Council for the petitioner, so also the Land and Council appearing for opposite party number 2 submits that though the state has filed the counter affidavit, but the copy has not been served on them.
Just now I am
The Land
extra
Council
copy
for the, all right, the Land Council for the state served the copies of the counter affidavit to the Land Council for the petitioner as well as Land Council for the opposite party number 2 in court. Put up this matter. That's the date they said. Okay.
Item 20.
May I please? I will see the last order where I am for the intervener in the IA at flag C. Chips had directed them to seek instructions in that intervention application.
I am for the petitioner, my lord. Petitioner is a auction purchaser. Since 2019 auction was in the year 2019 auction was held, I was the successful bidder, and a sales certificate has been issued in the year 2019 itself. And since 2019 till the filing of the writ, the possession was not handed over to the auction purchaser, for which I approached this honorable court in the present writ application with a innocuous prayer for a direction to the bank to give the physical possession and register the sales certificate.
What is the stand taken by the bank?
Bank has on initiative last occasion also, my lord, specifically directed that police authorities to take steps to hand over this thing. In between, they are not in the position, the state has to reply that.
I have for another bank.
Yes.
And for another bank, this property that has been auctioned, I am actually the first charge holder. And the property on which I am the first charge holder, that is now being sold off by another bank, which is Bank of Baroda.
They were prompt enough to do it. They were prompt enough to do it.
This is something.
They remained like a fence sitter, my lords. And since 2019,
first charge holder.
Why have you not initiated the Darwaza default?
As soon as it came to our notice, we filed it. The guarantor.
By that time, sale is confirmed now.
The guarantor, in any event, the sale itself cannot. It's an invalid sale because I am the first charge holder. Therefore, I have filed this intervention. Therefore, I may be heard in this application is what my humble submission in my intervention application is.
I beg to submit something. My lords, this instant application filed by the intervener is not maintainable.
You were not filing objection.
My lords, I don't want to because I don't want to venture into the dispute between two financial institutions. I want to back out.
We want to back out.
My lords, my money may be returned with FD rate.
Pay it and fight it out.
Yes, let them fight it out because this is not the appropriate forum.
Why not let this matter be
He has
referred to
to
the
challenge.
mediation? Mediation ତ ଆପଣଙ୍କର ସେ back out କରିଯିବେ କଣ ଅସୁବିଧା ଅଛି?
ମୋ ଆମର କିଛି objection ନାହିଁ. If he wants to take back his money, that was initially also I was submitted
With
because
interest
another
we
bank
pay.
is there. Bank of India is also there in that.
It's all right.
It is not within the knowledge of the Bank of
Now
Baroda.
And this is also not the.
Why are you not filing an affidavit to that effect?
I want to take back my money.
Yes,
Yes, I'll fight. Yes.
because of you now know that what is the stand
Yes,
taken by the interim. Why are you entering into?
No, no, I don't want to. I don't want to. That is the reason I didn't file any objection to the intervention application.
Let them take money and go.
My
Get
lords,
back
my
money.
lords.
Let them fight it out.
When you will file that affidavit?
Because of my.
My lords, tomorrow I'll.
He become wise.
Tomorrow I'll file.
Tomorrow.
My lords.
So let it be listed on record.
They are Friday.
The learned counsel for the petitioner submits after going through the intervention application. His party is now ready and willing to back out, and therefore he will file an affidavit to that effect. Put up this matter on 18th. Back out in the sense like to interested for refund of the amount which he has deposited with the bank along with interest, and along with the bank interest. Put up this matter on let it be on Wednesday. Put up this matter on 13th August 2025. An affidavit copy shall be served on the learned counsel for the bank. Okay.
We sort it out, pay him and finish it. Then
13th.
30. Okay.
Item 43, my lord. Item 43, sale is not finalized, my lord.
No, we are having this bench tomorrow also. So this rest of the matter will come tomorrow.
Tomorrow.
Right? Tomorrow, day after tomorrow, we are having this bench. So it will come tomorrow. Okay?
Yes, can this be taken up there?
No, if any matter you do not want to take it tomorrow, but day after tomorrow, give the that.
Only
just-
43. Item 40.
जो matter था mention को.
They have to go there.
Great.
I pay one thing, my sadly with my hoodie expired just first hour. So that I put it after the first board, your lordship first board. I don't know 14. I don't know 14. First board, not in the 3 store. First hour. First hour.
That will be taken up tomorrow and day after.
The lordship, I got it for that my case was raised to one. It is not signed. I pay for day after tomorrow.
I'm
So one criminal appeal, your lordship has admitted that against acquittal matters. Since no order for issuance of notice to the respondent accused, so the office is not accepting the requisition. So I pray let it be listed for orders on Monday. Monday, let it be.
Pardon to make a mention, my lord. In a criminal appeal, the prisoner has filed a prisoner's petition to engage Mr. Dilip Kumar Mishra and associates to conduct his case, my lord. May I humbly pray the matter may be taken up.
Item 64 for interim bills on state level. 64 ta file interim bills. Appellant number 1 son and appellant number 2
We have called
father
for a
was
report.
died.
Can it be taken up at 3 p.m.?
Yes. Call.
Supplemental list, item number 1.
You are appealing for the? Yes.
302 lines. 302 lines.
So this matter we called that man.
My lord.
Acha. Atgod jail le se ache.
Afterward this.
What is your good name?
Vikram Kesari Sandha.
Like Mr. Diktiranjan Mahapatra and his associates filed power for the appellant Bhaskar Naik, which is taken into account. The name of the newly engaged counsel shall be reflected in the cause list in place of the earlier named counsels. Hard admit, call for the trial court report. So, have you got the entire documents with you? Criminal appeal memo,
Yes, Lord.
judgment copy.
Yes.
So, what chita apna paile? Interim application has been filed for bail and sterilization of fine. That copies are with you. That will be considered after receipt of the trial court report. ଏଠି ଗୋଟେ ନମ୍ବର ଦେଇଛନ୍ତି 1227 of 2018, but in fact ଦିଟା interim application file ହେଇଛି, ଗୋଟେ ବୋଧେ stay ହେଇଯାଇଛି ନା fine stay ହେଇଯାଇଛି. So only this is to be left out of this matter. So you have received the deposition copy. You supply the deposition copy to the state council. The deposition copy will be supplied to the London council to the state. Ki appear କରୁଛନ୍ତି virtual mode. In which case?
Number 12.
So, all right. Yes.
Item 2.
The appeal has been filed against the order of acquittal. My lord, on 21/4/25, your lordship had directed the state council to take instructions.
My lord, I pay for time, both time.
Have you made any communication?
My lord.
When?
23rd April 2025.
23rd April.
My lord.
To whom you have addressed it?
Superintendent of Police Municipal.
Because in this type of cases, the opinion of the public prosecutor is taken and that is forwarded, okay,
My lord.
to the Director of Public Prosecution.
My lord.
Director for Public Prosecution submits the records to the London Advocate General, and if it is routed through,
My lord.
then permission is taken and ultimately petitions are filed. So that is the process. So now the Superintendent of Police has not given any response to you,
I contacted with him, which took time.
but you have written him on 23/4/2025. So more than 3 months have passed. कौन चाहते पर्सनल अपीयरेंस करेगा?
More time. Some time.
No,
More means how much more?
has you
Two
done
weeks.
anything?
2 weeks.
Onerous duty on you, and don't leave this type of fellow. अपन को respond करिए, चुपचाप बसिए. आप ask him to join. Why he has not responded? If you have written, ask him to join.
Man.
Pass over.
Item 3.
May I please, Lords? This appeal is directed against the rejection of bail. It is a schedule offence of the NI Act. This appeal is filed. On the incident took place in 2012, 10 to 2012. And the man was inside custody from 23/7/2012.
It is against conviction.
No. Rejection
Under
of
the
bail.
NI Act, National
Rejection of
Investigations
bail
Act,
under the
21 of the
NI
NI Act.
The case is pending before the special court Bhubaneswar.
Does it come to the division bench or single judge?
Yeah, the division bench.
21(4) says that any order passed by the special court that will lie to the appeal to a division bench. That is not the appeal, but the order.
Just a minute.
National Investigation Agency Act 2008.
You have got the records with you.
Madam. So for the charge sheet and other connected records, I got my, which shows 4 number of cases are pending against him.
Apart from this case.
Apart from this case, all
This
are
case,
304 case.
just a minute. This case relates to.
Chitrakonda PS case number 7. And subsequently NIA taken.
Just a minute. What is the PS case number? Where have you mentioned? NIA PS case number 2 dated 28/6/2012. So
Initially Chitrakonda PS case number.
Annexure 1.
Thereafter it was transferred to the National Investigating Agency. So if you say that there are other cases.
Other cases are there.
Tell the number so that he can take instruction about the status of the This case belongs to which one? Itaoji number Chitrakonda. That means number 2 re jota dekhayichanti apun.
Again.
Chitrakonda PS case number 8 of 1.
This is my road so far.
7.
Chitrakonda PS case number 7.
7 mane kuda.
8 jota Charlie seଟା 7.
ଆପଣଙ୍କ ଏଇ ଯୋଉ ତାକୁ ଛାଡିକି ନା ଲେଖନ୍ତୁ the Learning Council for the Union of India has produced the written instruction wherein it is stated that apart from the present case, that is NIA PS case number 2 dated 8/6/2012, which arises out of Chitrakonda PS case number 7 dated 10/2019.
12 my 12.
2012
again 19
there are 4 other cases instituted against the petitioner, and those are it lekhi debe ଆପଣ ଏଟା ଦେଇଛନ୍ତି ଚିତ୍ରକୋଣ୍ଡା PS କେସ୍ 48 ତାର ଏଇ ଯୋଉ ଇଏ କେସ୍ ନମ୍ବର କେତେ ସେଗୁଡା ବି ରେଫର ହେଇଥିବ
that I will provide.
କାରଣ ଏଠି ଯେମିତି NIA କେସ୍ ହେଲା
ଏଗୁଡା ଟ୍ରାନ୍ସଫର ହେଇଛି
ଏଗୁଡା ଟ୍ରାନ୍ସଫର ହେଇଛି ନା
state police cases.
state police ଲେଖିଦିଅନ୍ତୁ submit that there are 4 other cases instituted against the petitioner. That is a case number गुड़ा दे देवे चित्रकोंडा PS case number हमको हला the
fourth one is paper matla case number 3 are
paper matla अच्छा हो जहाँ लिखा ही लिख देवे है ना Land Council for the petitioner seeks some time to obtain instruction about the status of those 4 cases and file a comprehensive affidavit serving a copy on the land council for the Union of India. है ना? ये केस नंबर उड़ा अपन टिप्पी अच्छी अच्छी अपन पर
application. He was in medical, admitted in medical. He was vomiting. Lord vomiting in other cases.
What is the interim application number?
Number 1856.
So for the interim application is
What
concerned, my
happened?
lord, he has not annexed a single paper medical document.
Just a minute.
He has stated that DD.
आइए number tag कौन थू व्यस्त हो गए?
Admission.
आइए which आइए?
IA 1856.
That आसीन तो केबे फाइल कले?
এটা স্যার ফাইল ହେଇଛି 9/7
1856 of 2025
ଆଜ୍ଞା
ଲେଖନ୍ତୁ
এটা ଅଛି ବି ଆପଣଙ୍କର
footage
ଆସିନି
ସେଇଟା ଷ୍ଟାଟସରେ ଦେଖୁଛି ଷ୍ଟାଟସରେ ଦେଖୁଛି ଆଇଏ ପାଇଁ ଲିଷ୍ଟ ଆସିନି ଷ୍ଟାଟସ ଦେଖୁଛି
ଏମିତି ଅଛି କି କିଛି ଫାଇଲ ନାଇଁ ଲେଖନ୍ତୁ the land and council for the appellant submits that he has filed an interim application for interim bail which has been registered as IN number 1856 of 2025 on केबे फाइल कले
9/7/25
9/7/2025. Copy of the interim application has been stopped on the land and council for the Union of India to seek some time to obtain instruction on this application. है ना? केबे रखियो अपन से status आनी किन देबे comprehensive affidavit file करिए 2 weeks for put of this matter in the commencing from 25th November. है ना? Yes.
Sir, may I say that let the state government bring the status because he is in jail. Difficult to gather all the particulars of the case.
No, you must be ଆପଣଙ୍କର ଜେଲ ରେ ଯେତେବେଳେ ସିଏ ରହିଥିବ ଏଇ ଚାରିଟା କେସ୍ ର ଯଦି ରିମାଣ୍ଡ ନିଆହେଇଥିବ ତାକୁ ତାହେଲେ ସେ ଚାରିଟା କେସ୍ ମେଣ୍ଟେନ ହେଇଥିବ ତା ଦେହରେ ଜେଲ ରେ
ମୁଁ କହିବି 13 ମସିହାରୁ 19 ପର୍ଯ୍ୟନ୍ତ ସେ ରହିଲା ଚାର୍ଜସିଟ୍ ଫାଇଲ ହେଲା ଏଇ କେସ୍ ରେ 14 ତାକୁ ଦେଖା ଚାର୍ଜସିଟ୍ ତା ନାଁ ନାହିଁ ସବସିକ୍ୱେଣ୍ଟଲି 15 ରେ ଚାର୍ଜସିଟ୍ ସବମିଟ୍ ହେଲା 19 ରେ ସେ ବାହାରକୁ ଆସିଲା ପରେ ଘରଚ
ଆଡ୍ କରିଦିଅନ୍ତୁ since Mr. Jena expressed difficulty in obtaining the status of those 4 cases, let the Land and Council for the Union of India also obtain instruction relating to the status of those 4 cases, and apprise this court on the next date. Dita ko roila ji ani.
He is Naxalite leader.
Naxalite for BSF persons killed.
That was and views of hiring counter.
Next.
Item 4.
That should the appellant has been convicted under section 103 subclass 1 for life, which may be extended to 20 years. Lordship and other offences are 109 subclass 1 for 10 years and fine of rupees 2000 and further SI for 1 month. Lordship another offence is 64(2) subclass K for 14 years and 10,000 filed in default for 6 months.
What are these offences under IPC?
Lordship IPC, Lordship
1031 PNS.
302
103 tala
302
302 then 331
455
126
126 to 341
109
307
64
64 plus 376 and 132 or 355
132 da
355 353
all right life imprisonment
life one.
Yes, sir. Yes, sir.
Hard admit call for the trial court record. Interim application for bail and stay relation of time to be considered after receipt of the trial date record. In the meantime, the Land Council for the appellant will supply the deposition copies of the witnesses to the Land Council for the state. Put up this matter. Date they going to use a proper. Yes.
Item 5.
That the appellants have been convicted under section 302 of the IPC and other offences and sentenced to undergo life imprisonment. Madam.
Apart from other offences. Yeah.
Apart from other offences, 341, 323, 325.
Admit all for the trial court record, same order, interim and deposition copy to be submitted. Yes.
The deposition copy are annexed to it.
Acha, cut it then, Sita. You have got the deposition copy and all.
Obliged.
Item 6.
Let me. The case on section 302 conviction. Life sentence.
302 life.
Admit
And fine of rupees 50,000.
all for the trial court record, interim obligations to be considered after receipt of the trial, the deposition copy to be supplied. Yes.
So stay realization of fine.
It will be considered simultaneously. We are admitting and calling for the trial court.
Right.
Next.
Item 7.
When you also I pray, can you take on next week any day?
Next. We commencing for going to 18th of August 2020.
Item 8.
Item number 8, we have already filed
Milords,
objection
in item 8,
What is this?
Milordships in item 8, Milordship in item 8, I am through VC Lordships.
Since there is a
Lord-
774 days.
You delay of 708 days.
Yes, 708.
Yes, Lordship.
What is the sentence imposed, Mr.?
Life, Lordship, life for 302, and some punishment for some other offences also, like 447.
What is your objection, Mr. Madam?
The formal objection.
No, is it on record, your objection?
They have e-filed since 1/8 or so, that is not on record.
Objection to
Lords,
the file is not yet filed today. Keble file kar denu, got a copy.
1/8.
The mortgage unta na madam ko prison. Year number so and so, this is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 708 days. Land Council for the state has filed objection to the delay condonation application. After hearing the Land Council for the respective parties, going through the amendments taken in the interim application as well as the objection. And since the petitioner is sentenced to life imprisonment, we are inclined to condone the delay in filing the criminal appeal. Accordingly, delay is condoned, IA is disposed of, hard admit, call for the trial court record, interim applications for bail and stay realization of fine to be considered after receipt of the trial court record. The deposition copies be supplied to the Land Council for the state in the meantime.
I'm so grateful.
Item 9.
Item number 9. This is a matter under the POCSO, Your Worship. A notice is to be issued to the informant.
Informant is appearing.
I am
I am appearing in 1313 of 2024, Your Lordship. There are two items, my lord. I am appearing in the first item.
How many persons faced trial?
2 persons.
No,
Three persons present.
all of them were found guilty.
We are found guilty under 302 in 1313, husband and wife, Chakradhara and Anima, and he was found guilty 302 along with 6 POCSO Act, Your Lordship. We are not found guilty under POCSO Act, Your Lordship.
Chakradhara, you are appearing for Chakradhara.
Chakradhara and Anima, Your Lordship. There are two appellants.
In the jail criminal appeal under POCSO, there is no IA for the bail or anything.
No, that's easy. We just want to see that who has been convicted for what offences. So,
Chakradhara and Anima is convicted under section 302, Your Lordship. Replace of fact, Your Lordship.
Just give them. And with Chintamani,
I am appearing for.
there is no bail applicable.
I will file it.
You will file it. Yes, what is your case?
Well, the case is like that. This victim girl is staying with us.
Where's the
She was-
period undergone?
The body is 4-degree burn, parts of the ribs, walls, cartilage, parts of skulls involving frontal, partial, and bones or nasal bones, membranes, brain and brain matters were completely burned. On dissection, the thorax deposit carbon particles were absent. Heart was filled with blackish colored blood. The stomach contained 50 ml of viscera, fluid-like particles. The genital organs were completely burned. All the injuries are antemortem in nature. The death caused by 12 to 14 hours of the examination. A part of the heart, spleen, lungs, and kidney of the available stomach, a small intestine were preserved for common salt solution and chemical analysis to find out the exact cause of death. This is my report, so and so, and this is my signature on 34th 2008. IO marked the query about the nature of born death, and on examination, I opined that homicidal burn cannot be ruled out. This is my report as Exhibit 6 and 6/1, my signature. Cross-examination, the death of the victim could be caused by due to accidental burn injury, except the partial part of mentioned in my Exhibit 5. All the portions of the body of the victim is fully burned. It may be possible that a small child will senseless, then strain the carbons may not present in the larynx and trachea. And Lordship, kindly see the evidence of the IO in No, cross. why have you been convicted on what basis? My lord, say the on suspicions, Lordship.
No, suspicion whether.
Generally,
Yes, ma'am,
Can I
what is
take
the
a
basis of
picture in-
conviction?
Can I take a password in this matter?
Lordship, kindly see this.
Take it, pick up on some other day, we'll go through it.
Lordship, there is absolutely no direct or
The land council for the state seeks some time to go through the brief put of this matter. Next week.
The informant can be supplied a copy of.
Along with the observation letter, I will file.
It asks you will file it.
A copy to the informant.
The copy of the appeal memo be served on the land and council for the informant. So also the copies of the interim application for bail. Allah?
Item 10.
For the item number 10, my lord.
Yes.
Prisoner petition along with is.
Prisoner's petition is there, but where is your Wakalatnama has sent? Acha. The prisoner's petition has been received for engagement of Mr. Sarosh Kumar Nautway as his advocate. Wakalatnama has also been sent. Let Mr. Rautray be permitted to fill up the Wakalatnama. The name of Mr. Amitabh Tripathi shall not be reflected in the cause list henceforth. What is this jail criminal appeal for? Admission है यही क्या?
Admission all.
ठीक है.
Lord, office may be directed to LCR copy to my pen drive.
Trial court entire LCR get the deposition copies. The Mr. Rautray be permitted to take the deposition copies, soft copy of the deposition of the witnesses examined in the trial court in his pen drive. Yes.
My lord, one more submission that appellant is aged about 73 years.
You have not moved up.
They have not filed any.
File bail application.
File and make a mention. And once you are 73, then it is to be routed through the DLSA, comes to the High Court Legal Services Authority, and therefore it will come. There is a format for this 70 years and terminal ill. So it has not come. We do not know what is your age.
There is a scheme. There is a scheme.
NALSA guideline.
NALSA guideline.
On that basis, you can get.
I will file bail application.
Yes.
I will file it.
Publish.
Item 11.
From 11, the convict has been released prematurely. The convict has been released prematurely.
Premature release.
ସେ ଯୋଉ ମାନେ କୁଆଡେ ଯାଉଛନ୍ତି ସେ ଯୋଉ ପିଅନ ଗୁଡା
Madam, you premature release in
Since
2009.
2008.
8, huh?
1/11/2008.
Why these are not informed earlier? Why are you don't try to found out a mechanism wherever the accused are
The last time
prematurely released?
directed the registry, that's why it is this.
Not registry. You should keep the whoever is released along with the appeal number so that we get it listed.
There is a standing order given to the all the jail authorities. Till
ନାଇଁ ନାଇଁ
Follow it
ଆପଣ
up.
ଆମେ ଗୋଟେ କାଲି ମଧ୍ୟ କହିଥିଲୁ ଯୋଉ କେସରେ ଆପଣ ପାଇଯାଉଛନ୍ତି ଯେ ଏଇଟା ଡେଥ୍ ହେଇଯାଇଛି ପ୍ରିମାଚ୍ୟୁର ରିଲିଜ ହେଇଯାଇଛି
Will make a mention.
ଆପଣ ସେ ନମ୍ବର ଗୁଡାକ ଦେଇଦେଲେ ଆମକୁ ଆମେ ସେଗୁଡାକ ଲିଷ୍ଟ କରେଇଦେବୁ
Yes.
ଆପଣଙ୍କ ଅଫିସରେ ଏଜି ଅଫିସର ଆସିଥିବ ନା?
ସବୁ
List
ଆସୁଛି
ହେଲା ବେଳକୁ
ଲିଷ୍ଟ ହେଲେ ଆସୁଛନ୍ତି ଆପଣ
ଲିଷ୍ଟ ନୁହେଁ ଆପଣ ଇନ୍ ଆଡଭାନ୍ସ ଦେଇ ଦିଅନ୍ତୁ ଆପଣ ଆଉ ଗୋଟେ ଦାୟିତ୍ୱରେ ସେଠି ରଖନ୍ତୁ କାରଣ ଚିଠିଟା ଯାଇଛି ଆପଣଙ୍କ ତରଫରୁ ତ ଆସୁଥିବ କରେସ୍ପଣ୍ଡେନ୍ସ ହଉଥିବ ଦିଟା ତାକୁ ଡେଟ୍ କରିଦେବେ ଆଇଦର ଡେଥ୍ ହେଇଥିବ ନହେଲେ ପ୍ରିମାଚ୍ୟୁର ରିଲିଜ ହେଇଥିବ ତାର ନମ୍ବର ଟିପିକି ରଖିବ ଆପଣଙ୍କୁ ଦେଇଦେବ ମେନସନ କରିଦେବ ଦେଖନ୍ତୁ
ନାଇଁ see 2000 see let us see 2008 he was released. Why this letter is on 6th 8 2025?
Since it is
You have asked.
Since it is listed, we
That's the problem. See prison director prison is
no ହେଇଯାଇଛି already order ହେଇଯାଇଛି they have passed in the other division bench
last year.
not coming.
that order we have passed
Last week already got order ହେଇଯାଇଛି. Since it was listed, we
ସେଇଥିପାଇଁ ଆସୁଛି instruction order ଏଇ ଆସିଲାଣି ବୋଲି ହଁ the land and council the state has produced the ସେ ଯୋଉ order ଆମେ କରିଥିଲୁ ସାର୍ଙ୍କୁ ନେଇ ଦେଇଦେବେ ସେ order ଦେଖିନାହାନ୍ତି
I repeat କରିଦିଅନ୍ତୁ you repeat କର
advocate ଗୋଟେ ହେଇଛି ଯୋଉ ଆଙ୍କୁ ଦିଆହେଇଛି ରେଜିଷ୍ଟ୍ରାର ଜେନେରାଲ ପଠେଇବେ ଆମ ଗୋଟେ ଆଉ ଗୋଟେ ଆଡଭୋକେଟ ଜେନେରାଲ ଅଫିସରେ ମଗାଯିବ ତେଣୁ ଗୋଟେ ସବୁ ମ୍ୟାଟର ଫ୍ରମ୍ ଅପ୍ ଟୁ 2005 କି କେତେ ପର୍ଯ୍ୟନ୍ତ ଆମେ କହିଦେଇଛୁ ଯେତିକି ପେଣ୍ଡିଂ ହଁ 96 to 2005 ପର୍ଯ୍ୟନ୍ତ ସବୁ ଗୁଡାକ ପଳେଇ ଆସିବ like he has produced the written instruction receipt from so and so that the appellant has been released prematurely by the order of the government on 22/1/2009. The written instruction is taken on record. This criminal appeal is disposed of. Yes.
Item 12.
and item number 12. There are three appellants. They have filed a jail criminal appeal from the jail. Thereafter, they have filed the same criminal appeal. That's why they are in the VC. Your lordship are directed in the jail criminal appeal if they want to engage some other lawyer or anything. They are in there.
No. Appellant number 12 pehla criminal appeal 71.
So there are three convicts. Three of them preferred jail criminal appeal 101/24. Thereafter, through the
If appellant convicted life imprisonment offense under section 302 and other offenses in 307, but delay is there 50 days delay.
51 days of delay.
IA number so on so, there is an application for condonation of delay.
360.
The stamp reporter has pointed out that there is delay of 51 days. Condone kar debe, admit kar debe. Baki interim application to be considered after. Yes, delay condone.
Stay delay sir.
As a kathara ho bicharo. As your trial court report.
Item 14.
Item 14 have been permitted, my lords. Appeal against conviction for offence under section 302 IPC and sentence is life imprisonment, my lords. There is a delay, my lords.
624.
Delay condone. Admit kar diyantu. Interim application achi bail pai na nahi.
At present is not there, my lords.
Next.
Stay relation fine is there, it will be considered.
State of consider for them. Stay relation of fine for them. Bail to the Next.
Item 15.
May I please, my lord? Appellant is convicted under section 302 and 34 of IPC, my lord. My lord, there is a delay of 38 days, my lord.
36 days.
36 days.
So delay condone, admit, call for the trial court report. Baki the application file ko then the stay away have to be considered after receipt of the trial court report. Yes, next.
Item 16.
Is the appellants have referred this criminal appeal challenging their order of sentence and conviction under 302, 201 and 34 IPC.
Or 44 days.
44 days. Yes. So, delay condone for you. Admit for you. Baki file करचन the interim application.
Bail and stay.
That will be considered after receipt of the trial court report and we supply the deposition copy. Yeah.
Item 17.
May I please, madam? Yes, here the appellant has challenged the order of acquittal passed by the first additional section just Barikada, my lords, under section 498, 304B, 302, 34 of IPC and section 4 of DPRP.
Notice has to go.
There is a delay of
10 days.
Delay has to be, notice has to go because it's not the state only, it's the private. Look on the IA number so and so there is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 10 days in filing the delay condonation application. Issue notice on the question of limitation. Requisites for issuance
Days fine. He's
Conviction.
conviction in the offense under section 302 of IPC. For
Life imprisonment.
Yes, my lord, life imprisonment.
Right,
63 days delay.
IN number so and so. The delay is 63 days. That is to be condoned. I admit. Call for the trial court record. Interim application file korichendi.
Yes, my lord.
Interim application for bail and stay relation of fine to be considered after receipt of the trial court record. Yes.
Item number 19.
Convicted under section 302 matter. For life matter, delay is there now. If one is-
ଏଇଟା ଗୋଟେ ବୁଢାଇ ଦିନ ଅଛି ଏଇଟା ଗୋଟେ objection file 168
6 sir.
IN number so and so this is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 1687 days in filing the criminal appeal. The land counsel for the state seeks some time to file objection to the delay condonation application. He shall also obtain instruction to the jail superintendent if any jail criminal appeal has been preferred. Hala? Se bele file kar di thanti jail criminal appeal tanko न जणैथिबे ये तार से प्राइवेट वकीलों को एंगेज करी फाइल करथिबो तो से विषय इंस्ट्रक्शन नहीं जान हां फ्री कॉपी ऑफ द ऑर्डर बी हैंडेड ओवर टू द लैंड काउंसिल. Yes. Put up this matter after 3 weeks आउछु आ भीतर ऑब्जेक्शन डाई फाइल कर देबे आ जदी जेसीआर ले हेइथिबो त नंबर ता नहीं आसीबो है ना.
Item number 21.
Imprisonment of life, pay a fine of 10,000 and defer the payment of fine undergo RR.
Life imprisonment.
Yes, ma'am.
Offense.
Section 302 of.
302.
Yes.
IN number so and so this is an application.
15.
Condonation of delay. Stamp reporter has pointed out delay of 115 days, delay condone, hard admit call for the trial court record, interim application to be considered after receipt of the trial court record, but deposition copy to be supplied.
Item 22.
To my lord, the jail criminal appeal preferred by the applicant already disposed of.
Judgment appeal dismissed ना ना नहीं सेटा से दी गई थी अच्छा जेल criminal appeal allowed is left is the same judgment, are you sure?
Yes.
देखिए additional session judge Sambalpur jail criminal appeal judgment है additional session judge संबलपुर ST नंबर ला 136/7 of 1998 23/12/1999 बर्तमान क्रिमिनल अपील जजमेंट को पढ़ा सुनू जो संबलपुर 136/7/1998 डेटेड हला 23/12/19 ठीक है लिखो since the अच्छा ये ठीक क्रिमिनल अपील के जण अपेलेंट अछंती
जणे किशोर
Bag was the also the appellant there, right? Look, it appears that the appellant Kishore Bag has preferred jail criminal appeal number 48, JCRLA number 48 of 2000, challenging the judgment and order passed by the London judgment dated 23/12/99, passed by the London Additional Session Judge Sambalpur in ST case number 136/7 of 1998 in convicting him under section so and so and sentencing him to so and so. And in the said JCRLA had judgment and order dated 5/8/2010, he has been acquitted of the charge and the jail criminal appeal is allowed. In view of the judgment pronounced in JCRLA number 48 of 2000, this criminal appeal is disposed of.
Item number 23.
Number 2 has joined in this.
Item number 2.
Item 2.
Who is he? Who is he?
DSP Balangir.
DSP. What is his name?
Ajay Kumar Tirke.
Please give it.
Ajay Kumar
Mr. Ajay Kumar Sethi.
Tirke.
Mr. Tirke, you are the Deputy Superintendent of Police. So this criminal appeal number 423 of 2025, this has been filed by the informant challenging the order of acquittal in a case under section 302 and other offences. So we passed an order on 21/4/2025 asking the London Council for the state to obtain instruction as to whether the state is contemplating to challenge the judgment and order of acquittal or not. So this order dated 21/4/2025, we are told by the London State Council that it was intimated by letter dated 23/4/2025 addressed to Superintendent of Police Balangir to give his opinion after, of course, consulting the public prosecutor. But more than 3 months have passed
and no response has been received, and the Land and Council for the state was again seeking time. So what is the problem? Why are you not responding to the letter written by from the Office of the Advocate General?
ନାଇଁ ଆକ୍ଚୁଆଲି ସାର୍ ମୁଁ ଆଜି ସାର୍ ସେ ଚିଠିଟା ପାଇକିରି ଆଡଭୋକେଟ ସାଙ୍ଗରେ ବି
ଆଜି ପାଇଲେ ଚିଠି?
ସାର୍ ସାର୍ ପୁଣି ଦେଇକିରି
ଡେଟ୍ କେବେ ଚିଠି?
23/4/25.
23/4/2025 letter को अपन आज ही पाउचंदी. Is that letter is dated 23/4/2025?
ନାଇଁ ଅର୍ଡରଟା ସାର୍ ହ୍ୱାଟ୍ସଆପ ରେ ପଠେଇଲେ ସେଇଟାକୁ ହିଁ ଦେଖିକିରି ମୁଁ ଆଜି ଚିଠି ଗୋଟେ କରିଦେଇଛି ସାର୍ ମତେ ମୋ ଟାଇମ ଗୋଟେ ପ୍ରେୟାର କରିଛି ସାର୍। ନାଇଁ ନାଇଁ ଆପଣ ସେ ଏଡଭୋକେଟ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଏଡଭୋକେଟ ଆପଣଙ୍କୁ ଯୋଉ ଚିଠି ଦେଲେ କେବେ ପାଇଲେ?
ଆଡଭୋକେଟ ଜେନେରାଲ କ ଅଫିସ ରୁ ଗୋଟେ ଚିଠି ଆପଣ ପାଖକୁ ଯାଇଥିଲା. ସେ ଚିଠିର କପି ମଧ୍ୟ ଏଠି ଆଭେଲେବୁଲ ଅଛି ଏବଂ ସେ କପିରେ ଲେଖିଥିଲେ ସେମାନେ ଆପଣଙ୍କର ଓପିନିଅନ କଲେକ୍ଟ କରିକିନି ପଠେଇବା ପାଇଁ। ତେଣୁ ଆଜି ପର୍ଯ୍ୟନ୍ତ ପଠେଇଲାନି। ଆଜି ଯୋଉଟା ପଠେଇଛନ୍ତି ସେଟା ଅର୍ଡରଟା ପଠେଇଛନ୍ତି 21/4/2025 ର, କିନ୍ତୁ ତା ପୂର୍ବରୁ ଗୋଟେ ଚିଠି ଆପଣଙ୍କୁ ଯାଇଥିଲା। ତ ସେ ଚିଠି କଣ ହେଲା, କଣ ପାଇଁ ରେସ୍ପନ୍ସ ଦେଲେନି, ସେଇଥିପାଇଁ ଆପଣଙ୍କୁ ଭର୍ଚୁଆଲି ଆପିୟର କରିବାକୁ କୁହାଗଲା।
ସରି ସାର୍ ମୁଁ ସାର୍ ଆକ୍ଚୁଆଲି ସେଟା ମୁଁ ପାଇନି ସାର୍। ମୁଁ କନସଲ୍ଟ କରୁଥିଲି ଏସପି ସାଙ୍ଗରେ ବି କନସଲ୍ଟ କରୁଥିଲି। ତାପରେ ଆମର ଆଡଭୋକେଟ ସାଙ୍ଗରେ କନସଲ୍ଟ କରିକି ସେଇ ଚିଠିର ହିଁ ରିପ୍ଲାଏଟା ସାର୍ ଦେଇଥିଲେ କି ମୋ ଟାଇମ ଟିକେ ଦିଆଯାଉ।
ଆପଣଙ୍କର ସୁପରିଟେଣ୍ଡେଣ୍ଟ ଅଫ ପୋଲିସଙ୍କର ଅଫିସରେ ଯୋଉ ଆଡଭୋକେଟ ଜେନେରାଲଙ୍କ ଅଫିସରୁ ଯାହା ହଉ ବା ଆମର କୋର୍ଟର ଯିଏ ରେଜିଷ୍ଟର ଜୁଡିସିଆଲ ବହୁତ ସମୟରେ କମ୍ୟୁନିକେସନ କରନ୍ତି କୌଣସି ଇନଫର୍ମେସନ ପାଇଁ, ତାର ଗୋଟେ ସେଲ୍ ଅଛି ତ ରିସିଭ କରିକି ତାର ରିପ୍ଲାଏ ଦେବା ପାଇଁ?
ହଁ ସାର୍ ଅଛି ସାର୍।
ତାକୁ ଡାଏରୀ ଏଣ୍ଟ୍ରି ନିଶ୍ଚୟ ହଉଥିବ କୋଉ ଚିଠି ପାଇଲେ, ତାର ରେସ୍ପନ୍ସ ଦେଲେ କି ନାହିଁ। ଚୁପଚାପ ବସିଗଲେ କେମିତି? 21/4/23 ଗଲାଣି ଚିଠି, 3 ମାସ ହେଇଗଲାଣି। So take the opinion of the public prosecutor, show him the judgment and other things, get the instruction, and you have to do the needful, because thereafter it is to be routed through the director of public prosecution, and sent to the advocate general office for giving your opinion. Okay.
Few days ଭିତରେ ସାର୍ ମୁଁ କରିଦେଉଛି ସାର୍।
We are giving you 2 weeks time. You collect all the data and give us, right?
ସାର୍ ନମସ୍କାର
So, Mr. ଆଚ୍ଛା।
ଆପଣ ବର୍ତ୍ତମାନ ଦେଲାରୁ not active.
When the matter was called in the first, when the matter was called, the Learning Council for the state sought for some more time to obtain instruction as for the order dated 21/4/2025. We put a pertinent question to the Land Council for the state as to when the order dated 21/4/2025 was communicated to the authority concerned, to which she replied that on 23/4/2025, a letter has been sent to the Superintendent of Police, Balangir, for what is the letter or yet they get pass on kone? They pass on kone, chirantini. On this aspect, seeking instruction, and along with the said letter, the copy of the order dated 21/4/2025 has been annexed, but no response has been received from the office of the Superintendent of Police. We asked the Land Council for the state to communicate or to contact the Superintendent of Police to join us through virtual mode, and accordingly, the Deputy Superintendent of Police, Mr. Swanso, appears through virtual mode and submitted that after receipt of the communication from the Land and Advocate General Office, he has already he has produced the letter dated 6/8/2025 of the Swanso,
and DSP appears to that 15 days time to be granted for obtaining a necessary instruction in the matter. Put of this matter in the week commencing from 1st September 2025. This communication is taken on the top of them. No? So, 1 तारिख दिन आसिबो ता भीतर आपण you do the needful.
Sir. Sir, namaskar, sir.
Mr. Bose is present खाली कर दो 1st September 2025. Next.
Item number 23.
May I see? After occasion of lordship for the possibility certificate of the appearance, my lord.
Got it.
Order please.
No.
कौन है ना?
Make corporate certificate as soon as same.
Get it next week.
My lord.
Land Council for the state seeks some more time to produce custody certificate. Put up this matter on 13th of August 2025.
Item 24.
Hello. The petitioner has been convicted for life imprisonment. And now Milord is in custody for more than 15 years. 14 years, 1 month.
अच्छी है अपन बैंक कस्टडी सर्टिफिकेट जजमेंट रिपोर्ट लिखाई जाए अच्छी आंसर
No, Moga enough. Like last occasion only prisoner petition was accepted.
All right, that's fine. Definitely. The Mr. Vani Shankar Das Land Council appearing for the appellant submits that the appellant is in judicial custody for 15 years.
14 years, 1 month.
For about 14 years. Let the Land Council for the state seek some time to obtain instruction in the matter and to produce the custody certificate. So also about the criminal antecedent, if any, and his conduct in jail. Put of this matter, 25/8/2025. Yes.
Item 25.
Lordship, in this matter, I am through BC. Milord, we have filed one IA, number 1911 in the criminal appeal 286/2016. Milordship, this criminal appeal was dismissed in default in the year 2020 due to the death of my father. I am the daughter of the convict deceased. Milords, it is a very surprising case that in which only one person was prosecuted and punished for life under section 120B, and finally he died. So the appeal was dismissed. After hearing my CRLMA on the merits, Honorable.
Okay, that has been, you are allowed to continue the appeal. So, keeping in mind the petitioner, the unmarried daughter is interested to pursue the appeal, court feels it proper to recall this one. So, hence the order dated is recalled and restored to file.
Lordship, the reason of urgency that he was in job, government job, and due to this conviction, the benefits has been curtailed. There are 3 daughters and 1 son in the family.
For order before the appropriate bench. What is the
prayer is for early hearing?
Just a minute.
Paper book is not ready, Lordships.
Please wait. Okay, the main petition, the main appeal,
Yes, Lordship.
criminal appeal number 286 of 2016
Yes,
has
Lordship.
now been restored to file,
Yes, Lordship.
right?
Yes, Lordship. By the order dated 7/7/25.
All right, but the appellant is dead now.
Yes, Lordship. Yes, Lordship.
You are to file an application in the main appeal under section the 394(2) proviso to continue the appeal.
That application has already been filed.
No, that is not the application. The application was filed to recall that order, that the appeal was dismissed and accordingly it has been restored to file. But in the CRLA, the father is the appellant. The order has to be passed that in the CRLA, you will be permitted to continue the appeal. Then can only the things will be done and your interim application for early hearing will be considered. So that order has not been passed.
I will file that application in the meantime.
CRLA number 286 of 2016, Mr. Sam Manohar, Land Council, appearing for the appellant, submits that an interim application shall be filed by the near relatives of the deceased appellant to continue the appeal as the sole appellant is dead, and the matter may be taken off after. How much time you want? Mr. Manohar, we are not able to, please unmute yourself.
Lordship, we will file the application in 2 days. 2 days only.
All right. We want
This week.
1 week, 1 week. The matter be listed immediately after the filing of the interim applications and serving a copy thereof on the Land Council for the state. Yes.
I'm obliged, Lordship. I'm so grateful.
Item 64, man.
Yes. Instruction ଆସିଲା କେତେ number item?
64.
64. Sigana Kalaka.
Singana Kalaka and Rabbi Kalaka.
No. ये तो 6 जन appellant ଅଛନ୍ତି ଏ ଯୋଉ interim application file
ସେ ହବ ଭାଇ
ବର୍ତ୍ତମାନ କୋଉ application ଆପଣ 2131
yes.
So this is an interim application filed by appellant number 1 and 2.
Yes.
Who is dead now?
My lord, the son of appellant number 1, who happens to be the brother of appellant number 2.
Wait.
Sam Kalka. Right.
Hmm. 24/7/2025. But the report has come.
Sam Kalka.
Hmm. चौबीस सात माने 25, 24, 25, 26, 27, 28, 29, 30, 31, 1, 2, 3, 4, 5, आज रानी 6 तो आज 14 दिन काम सरी
डेथ सर्टिफिकेट मिललानी से बापू को बात करला सरपंच भी लिखी देलेनी
कर्म सब सरी रानी खाली जाई 14 दिन 13 दिन ये दिन सोडा सॉरी जीवन सब
Interim bail.
My lord, no, not interim bail. I was on bail during trial, my lord. And the appellant number 1 is a 70 years old man.
You see, even today somebody made a mention that his father died today morning, and the urgent mention was made. We listed it by way of special notice and released him on bail. But why are you keeping the matter when after the obsequious ceremony is over? And what you will now do? Even if you were,
Nobody was ready to file affidavit before your lordship.
But why for you will go out? The
ବର୍ତ୍ତମାନ
every-
କଣ ପାଇଁ ଯିବେ ଆପଣ ଯୋଉ ଆପ୍ଲିକେସନ ଟା ଦେଇଛନ୍ତି the purpose of the application
Only for your lordship may say 7 days can Sudhi ita ହେଇକି ପଳେଇ ଆସିବ.
IA number so and so, this is an application for interim bail on the ground that son of the appellant number 1, who is also the brother of appellant number 2, namely Sham Kalaka, expired on 24/7/2025. The Learned Council for the and to perform the obsequious ceremony, the petitioner may be released on interim bail. To be released on interim bail. Learned Council for the state has produced the written instruction received from IIC, Isam Katak Police Station, dated 6/8/2025, wherein it is mentioned about the death of Sham Kalaka on 24/7/2025. The written instruction is taken on record. After hearing the Learned Council for the respective parties, averments taken in the interim application, written instruction received by the Learned Council for the state, we are inclined to release the appellant number 1, Sigana Kalaka, and appellant number 2, Rabi Kalaka, on interim bail for a period of 15 days. Put of this matter on such
The
as
date of his
from the date of the release. Put of this matter on such as the Learned Council for the appellant shall produce the surrender certificate, while an interim bail shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail.
in court.
Of the courts of the
The letter was not gone to the learned court below for sending of PCR. It was not communicated till date.
digitalized not received actually. Even though this appeal was admitted on 10/4/2025, but the digitized copy of the trial court record has not been received. The immediate steps shall be taken for getting the digitized copy of the trial court record, and for such purposes the file be placed before the learned registered judicial to do the needful. Yes, please.
Item 26. Item 26. First item lawsuit. It is filed for interim bail lawsuit.
26. The petitioner was on bail. He has not surrendered. Can I have a glance to the report?
Surrenders is very same day lawsuit.
The report is there at flag N.
I live in
Surrender certificate do you have?
no lawsuit.
How you will move a bail application? You are granted interim bail. You have been released. You have filed another interim bail application. So unless you are in custody, how can we grant you interim?
is in custody.
अरे आपण मौखिक कहले कोन हबो कि आमे तो कहितलु surrender certificate हां
The report is at flag N.
flag L
N. Report of the additional district session just came.
flag N कोन हला so and so the conviction is has not yet surrendered.
Lordship surrender certificate ଆମେ ଫାଇଲ କରିଦେଇଛୁ meantime.
ସେଟା ତ କୁହାଇଥିଲା ନା.
Unavailable warrant of arrest issue ହେଇ ସାରଲାଣି ଆପଣଙ୍କୁ ଆଉ କେବେ surrender କଲେ ଆପଣ?
No lordship, very same day within period of your lordship granted 40
If
days.
you would have surrendered, then NVW, then question of NVW.
प्रदीप कुमार गिरी ପାଇଁ ଆପଣ bail move କରୁଛନ୍ତି
Lordship.
ଏଟା ହଉଛି
No,
trial court ର report
lordship is other petitioners.
ପ୍ରଦୀପ କୁମାର ଗିରି. ପ୍ରଦୀପ କୁମାର ଗିରି ଦେଇଛନ୍ତି ରିପୋର୍ଟ.
It says convict appellant Pradeep Kumar Giri.
ଦେଖୁଛନ୍ତି କି?
appellant
Pradeep Kumar Giri in ST case number so and so has not surrendered before this court on 25/11/2024. He has to surrender on 24/11.
ଆପଣ ଆଉ ଗୋଟେ bail application file କରି ସାରିଲେଣି ଇଆଡେ submission କରୁଛନ୍ତି ସେ surrender କରିଗଲାଣି.
Lordship petitioner already surrendered on
Mr. Counsel,
24 lordship.
you file the surrender certificate.
Lordship, I am.
Then this is wrong then.
Lordship is wrong, lordship.
Please, Lordship.
Don't make such statement. Say trial court learning trial court ADJ is writing that you have not surrender, for which non-bailable warrant of arrest has been issued, and you are not producing and challenging that trial court has mentioned wrongly. Suppose it will record your submission and will call, can you file an affidavit that the trial court has mentioned incorrectly?
As per instruction, he is inside the custody. Surrender certificate next week they file.
That's a good idea. Do that. Don't do it problem.
IA number 1866 of 2025 is an application for interim bail. आपण जहाँ माइंड मेकअप करिन आस्थांती सेही सबमिशन टाकू कोर्ट रे करंतुनी कोर्ट रो प्रोसीडिंग देखि किनी माइंड को एडजस्ट करी सबमिशन को ट्विस्ट करियो पड़े दैट इज द एडवोकेसी हला माइंड मेकअप करिन आसी सिचुएशन कहूँ ट्रायल कोर्ट लगी आप सरेंडर करना वारंट हो जाइए तेणु यही सिचुएशन को देखिए आप कहवा कथा मत इंस्ट्रक्शन टाइम दिंतु रिपीटेडली आम कहूँ
वारंट एग्जीक्यूटिव हेइथियो तापर
peruse the report of the land and trial court at flag A N from the appears that the appellants Pradeep Kumar Giri has not surrendered on the date fixed for which non-bailable warrant of arrest has been issued against him. The Land Council for the appellant, on the other hand, submitted that he has instructions that appellant has surrendered before the Land Trial Court and he is now in judicial custody and seeks some time to produce the surrender certificate. Out of this matter, keep next week. Keep it on 18th of August 2025.
May please, Lordson. Item 26, my lord. First item, my lord. On behalf of Mr. Vijay Kumar Ragada, my lord. His name and association name be deleted, my lord.
Item number 25, Ray.
26, first item, my lord.
26 the name of Mr. Tardir Lekide, Vijay Kumar Ragad and his associates shall not be reflected in the cause list henceforth. Yes.
With next item, with items, the petitioner also released on interim bill, he has not surrendered.
In the same 26 item,
convicted co-op. CRLA 329 of 2006.
Mrs. Bedas. On behalf of Mrs. Bedas, I am submitting the bill also. Also, no information were about looking to.
About information of kind of. The Vavila Kolas here, na. जब से भाविला नहीं अब मो इंटरिम बेल ले जाई छी भाविला खलास हे गला पळेला पड यूपी लोक ना उत्तर प्रदेश लोक
yes that's the problem
एटा ये हितिबो निश्चय लोकल सिक्युरिटी ऑर्डर हितिबो
kindly have a glance to order dated 29/11/2023. We direct the trial court to take all such expeditious and coercive steps as provided in the law to rescue the presence of the appellant for being dealt further in accordance with law. The report to be asking.
Allahabad Uttar Pradesh look. Like on the CRLA number 329 of 2016. IA number 442 of 2020. This is an application for bail. And IA number 911 of 2020 of 23. This is an application for extension of interim bail. The Learning Trial has reported by letter dated 5/10/2023 that after availing the interim bail period, the appellant Vishnu alias Vishnu Shankar Pandey alias Arjun has not surrendered for which non-bailable warrant of arrest has been issued. And notices to the bailers have also been issued. Since the appellant has not complied with the terms and conditions of the bail order and not surrendered in time, both the interim applications are rejected. Stop. The Learned and Trial Court shall furnish the up-to-date report relating to the apprehension of the appellant, so also the status of the bail or miscase put up this matter in the week commencing from 1st of September 2025.
Next item also same.
363.
363.
ये कौन पढ़ेला? नहीं नहीं, ये कौन absconding कला? नहीं, ये लोग को कोड़ी आ रहा। हाँ, उत्तर प्रदेश रहा। सरेंडर ପାଇଁ କିଛି ଇଏ ନାହିଁ ତ ସେଟା ଇନଷ୍ଟ୍ରକ୍ସନ ଆସିବ ଟ୍ରାଏଲ କୋର୍ଟରୁ ଆଜି ତ କିଛି ଆସିନି ରିସିଭ କହିନି ଲେଖନ୍ତୁ ଆଇଏ ନମ୍ବର CRLA number 363 of 2016 the appellant Inder Amar Sonkar alias Kalia alias Raj alias Babu Keita Nadar Chattana has been directed to be released on bail by order dated 16/1/2023 for a period of 2 months and the Land Council for the appellant has not filed the surrender certificate. Rather, submits that he has no instruction whether the appellant has surrendered in trial court after availing the interim bail period or not. Let a report be called for from the Learned and Trial Court in that respect. File be placed before the Learned and Registered Judicial who shall send email 1st September 2025.
Next item also same. 286 of 2018.
Adir भी report मगा ही नहीं. केबे गला से bail जो interim bail?
He from Orissa.
1 month. कृष्णा बारिक ये लोग को हाँ इटा तो क्यों जो लोग का who is appearing for here?
Mr. Das.
Mr. Das. लिखो CRLA number 286 of 2018. The appellant was directed to be released on bail, interim bail, for a period of 1 month, as per order dated 1/10/2024. And there was a specific direction to produce the surrender certificate. None appears for the appellant. Surrender certificate has not been filed. Let a report be called for. Say the Purna order bane. Allow whether the appellant surrendered in the meantime or not. So it will be say first good date to rokhibe ago. 1st September 2025. With पळे आसिबो से अन्य आइटम जो कनेक्टेड आइटम्स गुडा अछि ता सहित आसिबो No. Yes, next.
Item number 27. The 26.
Ah. Grant of bail from custody certificate, criminal antecedent.
My lord.
Yeah.
No criminal antecedent, custody 9 years, 3 months.
9 years, 3 months. ଆଗରୁ ବେଲ୍ ରିଜେକ୍ଟ ହେଇଛି ଜାଣିନାହାନ୍ତି?
Judgment, why not? The occurrence was on the 16th.
No, ma'am, ପଚାରୁଛୁ ଆଗରୁ ବେଲ୍ ରିଜେକ୍ଟ ହେଇଛି କି? Yes, it has been rejected on
For the first time.
22/10/2020 ରେ ରିଜେକ୍ଟ ହେଇଛି ଆପଣଙ୍କର। Yes, one. Fifty case for answer. IN number one. So this is an application for bail. The Land Council for the state has produced the written instruction received from IIC Koksara Police Station to the effect that there is no criminal antecedent against the petitioner. He has also produced the custody certificate from the Superintendent District Jail Bhavani Patna. It shows that the petitioner is in judicial custody for 9 years, 3 months, 9 years, for more than 9 years. The documents filed by the Land Council for the state are taken on record. Stop. The Land Council for the petitioner submits that earlier the bail application of the petitioner was rejected on merit by an order dated 22/10/2020. However, in view of the period of detention in judicial custody and absence of any chance of early hearing, the bail application may be favorably considered. Land Council for the state opposed the prayer for bail, considering the submission made by the Land Council for the respective parties. Period of detention of the petitioner in judicial custody for more than 9 years, absence of any chance of early hearing, and keeping in view the ratio laid down in the case of Letty versus so and so, 3 months interim bail granted from the date of release. Yes.
Item number 28.
May I please, Your Lords? Last occasion, the custody certificate and this criminal antecedent has been
Just a minute. Find my note at the Honorable Chief Justice and letter of Resto Judicial Proceedings of Class B.
Creation of website of the director and the IG prison.
Particularly old the bail application were filed or he or can passport. So some judges purchase it. It also class period. In most of the cases, particularly in old criminal appeals where bail applications are filed for release of convicts, appellants, and we find the time is sought for by the Land Council for the state regarding production of custody certificates of this one. So from the concerned jail superintendent, for that reason, delay occurs in disposal of their applications. In view of the above, let a website be created by the Director General, PG Prisons, Government of Orissa, in which custody certificate of all the convicts lodged in different jails of Orissa, which shall be updated from time to time, relating to their period of detention, so that there would be not any delay in disposal of the bail application. Let a copy of the order be handed over to the land council for the state. The interim shall communicate the same so and so and place before council. तापर out order इकला ये करे अपन ये जो हमारा डेथ हाउ ये अपन से राशि मौके की नहीं करे अपन ये साइड ला ये ना असला इंस्ट्रक्शन तो नहीं
separate instruction.
देखिए एक केस को छाड़ी की नहीं उड़ा कितने केस अच्छी
मनोरंजन महापात्र 5टा, अक्षय महापात्र 2टा।
এটা হলো লিঙ্গরাজ পিএস কেস নম্বর 114 টা হচ্ছে 302 বাকি চারটি হল লাস্ট তাକୁ ଛାଡ଼ିକିନି ଆଉ ହେଲା ଚାରଟା ହଉଛି ମନୋରଞ୍ଜନ ଆଉ ୟାର ହଉଛି ଦିଟା ବାବୁ ମୋର ଅକ୍ଷୟ ମହାପାତ୍ର ଦିଟା କଣ ଆପଣଙ୍କର ଇଏ କଣ ଅଛି
Because I have no instruction, Lordship. I have to file a Lordship complaint regarding the
the Learned Council for the state has produced the written instruction received from the IIC Lingaraj Police Station, Bhubaneswar, regarding the criminal antecedents against the two appellants, which is
present
taken
bail
on-
application, Lordship, in respect of only Manoranjan, Lordship.
He has also produced the custody certificate from the concerned jail superintendent, which is also taken on record. The Land Council for the appellant files a date chart, and the same is taken on record. However, he seeks some time to obtain instruction regarding the status of those criminal cases and file a comprehensive affidavit to that effect. Put of this matter in the week commencing from 25th August 2025.
Obligers.
Item
Mr.
29.
Vijay Kumar Roger, Land Council, for the informant. Informant is present. And ye virtual Mr. Prabhas Chandra Jana, Land Council for the appellants, appears through virtual mode and submits so and so.
What with your website, anything development.
They have come and discussed with the
Time like
Item 29.
My lord, here the petitioner is languishing in jail custody for 11 years. And he has been convicted under section 302-201.
Just a minute, Mr. Prisoner's petition has come in your name and you have filed your vinama.
Yes. And in the year 2023, I have filed my original.
No, why this?
23.
Cause list कौन पे आसे चले अपन करो अपन तो appear करते regularly
23 ରୁ
20
23 ରୁ निकला ना भाई
ଦେଖିଲେ ନିରଞ୍ଜନ ପଣ୍ଡାଙ୍କର वकालत ନବା ପାଇଁ बिजनेस पिटिशन तो अच्छी वकालत नवा नहीं सेटा उसे आगो काउंसिल करो ଯେତେବେଳେ ଓକାଲତନାମା ଫାଇଲ କରୁଛନ୍ତି ତାର ଗୋଟେ କପି ରଖୁନାହାନ୍ତି ଆପଣ ଜେରକ୍ସ କରିକିନି ଆଉ ସ୍ଲିପ୍ ରଖୁନାହାନ୍ତି ଆପଣଙ୍କୁ ଦେଇଥିବେ ନା ଅଛି all right it's there leave it ଦେଖନ୍ତୁ prisoner's petition has been received for engagement of Mr. Niranjan Panda as his advocate. Mr. Panda has also filed his wakalatnama which is accepted. The name of Ms. Vijayalakshmi Tripathi and her associates shall not be reflected in the cause list henceforth. What is your prayer, Mr.
For granting bail.
No, no. Why have you filed one bail application, two bail application?
No,
three
earlier
bail
bail application filed by another advocate.
So
My
you
bail application is
not press karan soda.
These are not present, only 1905, sir.
Just a minute. IN number 1015 of 23 and IN number 2966 of 2023. These are the two applications for bail and interim bail. Mr. Pandal and counsel appearing for the appellant does not want to press this application. So it is not pressing disposed of. Hala. Baki rohila IN number 1905 of 2025.
Yes. My lord, he has been convicted under section 302 and 201 IPC and sentenced to undergo the imprisonment for life. And he is also languishing in jail custody, that is from 15/8/2014, 11 years.
Achi custody certificate.
Custody certificate. He has not granted bail.
Earlier was rejected on bar upon.
Bharatini?
Yes,
By
12/3/23.
Yes.
ठीक है
Sir.
Bar 8/2023. Rejected. But being that custody certificate, the learning counsel for the appellant, it will give IN number is 1905. This is an application for bail. Mr. Pandal and counsel appearing for the appellant submits that the appellant is in judicial custody since
2014. That is
Land counsel for the state seeks some time to produce the custody certificate and also obtain instruction regarding the criminal antecedent, if any, against the appellant. So also its conduct in jail. Hala. Put up this matter we commencing from 25/8/2025.
Item 30.
Prisoners. Appellant's application is convicted under section 363, 376, 2 and 2. 1717 of 2020.
ବାକି ତ କାଲି ବି ଆସିବ ଯୋଉଠି
will come Friday.
କୋଉଟା କହିଲା 63? No, tomorrow there is this bench will function also. After lunch there is another bench that Cuttack PIL, but prior to that in the first hour this bench will be there.
You take note tomorrow.
We'll see that how many matters, because this service matter and this criminal matter will be clubbed up in one list, because now it is segregated, because so now since after lunch there is a
that is why may I be permitted to pray that let it come top of the district lordship. I have already heard that matter.
No talk.
Because of that Odisha bond, the lordship was not inclined. That the government I wrote that
we
if
see
a
that
political man comes out of that
କେତେ କେତେ ମ୍ୟାଟର କାଲି ଆସିପାରିବ ଦେଖିକିନି, କାରଣ ସେ ଆଗରୁ କିଛି ଅର୍ଡର ହେଇଥିବ ଦେଖିକି କରିଦବାଟା।